May I have your lordship?
Yeah.
May I have your lordship need to mention any execution application? The execution was unconditionally stayed by the division bench at some point of time. The appeal has been dismissed on 8th of December by the division bench by an order dated 8th of December, lordship. Pursuant to the orders of the Supreme Court, this lordship. Lordship, the award is of 2009. I am mentioning upon notice. The notice is also there in the second page of that. Second page, the notice is there.
All right. You want the execution to be
Yes, lordship.
well listed?
Thank you.
I mentioned matter lordship. Ecom number 356 and 357 of 2024. Both the matters have been settled between the parties and with instruction and print. Great.
Lordship, may be permitted to mention to matter for withdrawal.
May be permitted to mention a matter from the determination of Justice Shubhoto Mujumdar, Your Lordship. Your Lordship has a determination for today. Your Lordship is praying for restoration of an application, Your Lordship.
What is the urgency?
Urgency, Lordship, the matter was...
Restoration will go tomorrow. What is the urgency in hearing a
Your
restoration?
Lordship, the restoration application, my limited 30 days expires today, Your Lordship. Then, Your Lordship, will kindly allow me to file my restoration application also, Your Lordship.
Why should I allow you?
Your Lordship, because the 30 days, I have to file it within 30 days, Your Lordship, and today's 30 days expire, Your Lordship, and the petitioner stays in Seattle, Your Lordship. So I'll have to get it apostilled and only then I can file in the department.
You can file it without the consent of the court.
Lordship, if the petitioner stays in Seattle, Your Lordship, so the document has to be apostilled and then only the department will take it, Your Lordship. And if I send it for apostille now, then Lordship, it will...
Without apostille, nobody is going to take your WS, right?
No, it's a restoration application.
Restoration application. Nobody will take it. I'm sorry, I can't allow this. It has to be apostilled.
Lordship,
It has to be apostilled, sir. Sorry, you have to go to the embassy, get it apostilled. Without apostille, no application is made. I can't allow this.
With the leave of your lordship, may I mention a matter which is being heard by Justice Saugata Majumdar.
Yes.
This is in respect of an interim order granted by him on 18th of November, which is expiring today, my lord. I request your lordship if the interim order could be extended, my lord.
I don't have the file. I have to call for the file. What is the urgency?
It is expiring today. They are in the process of surrendering their leasehold rights at rupees 60 crores.
I'm appearing for two of the respondents, my lord.
Yes.
I'll hand over the last order passed by his lordship.
Is there a difficulty, Mr.
No, there's no difficulty as such. I'll be candid. In any case, my lord, the order is valid till the next date. And interim order is extended till date. So as and when the matter is taken up, in any case, the interim order should be valid till then, but I leave it to your lordship.
We'll keep it at 12.
No difficulty. I'll be here.
We'll keep it at 12. We'll fix it at 12 o'clock today.
Grateful.
We'll publish the supplementary list. Let it be. Just let it.
My lord, item number 1 I'm for the
You'll be
petitioner.
here. I'll be here at 12, my lord.
My lord, I'm for the petitioner. I'm led by Mr. Kumarjit Banerjee. He's appearing online, my lord.
In order to do complete justice, this court inquired from both the parties as to whether they would consent to the appointment of substitute arbitrator by this court for adjudication of the dispute between the parties. Both parties stated that they have no objection to the appointment of an independent arbitrator by this court. Accordingly, Saik Ranjan Ganguly, so and so, is appointed as the arbitrator to decide the dispute between the parties. The learned sole arbiter shall be at liberty to determine his fees and other terms in accordance with law. In view of the foregoing discussion, the present petition is allowed.
I'm deeply obliged, Your Lordship. I'm deeply obliged. Obliged, Your Lordship.
Your Lordship, item number 2, kindly grant a short passover. My senior couldn't be here.
Not today.
This is my section 9 application.
For my learned senior friends, last occasion when the matter had come up, my lord, 3 days ago, we had told your lordship, my lord, our clients are situated outside of Calcutta, my lord, so the Wakalatnama had not come. Wakalatnama affirmed has come, my lord, only stamping and punching is left. If your lordship will kindly record my undertaking, that I will file it in the course of the day, my lord.
File it in the course of the day, then the matter will be listed.
Yes, my lord.
If they're filing it in the course of the day,
His Lordship will record his undertaking, my lord, that he'll file, my lord.
Yes. It is in hand, my lord. Only the stamping and punching is left. We will file it in the course of the day.
Well, this is a section 9 application, my lord, which has been, this is a second round, I would say, my lord, of a proceeding which has been filed before my lord in respect of an agreement, my lord, which, my lord, the parties have entered into for a financial facility. Now, my lord, this agreement is a kind of an agreement, my lord, in which, my lord, the borrower is going to give us, my lord, certain invoices. Now, my lord, based on the invoice, since, my lord, he does not have the purchasing power, my lord, I am supposed to pay them, and the borrower would thereafter reimburse me. If not, with, my lord,
so let them file this. Then we'll have it.
file, my lord.
Let them file their reply.
My lord, here I am praying for an interim order because, my lord, no payments have come in, my lord. It's a huge due. And, my lord, I'm seeking a very, my lord, innocuous interim order, my lord. I'm only asking they should not deal with their bank account. Because, my lord, the amount due is, my lord, more than 2 crores. And, my lord, there has been no payments which are coming in, my lord. And, my lord, therefore, my lord, they should not utilize the bank account. So, my lord, I'm praying for an interim order, my lord. And from the records itself, it is apparent that no payments have come in. And there is a period of 90 days.
1 day time to file their reply. They'll be
No,
today.
they have not sought for any time to file reply.
On the undertaking, if your lordship
ready,
permits, my lord, I am ready to argue today, my lord.
Oh.
They have the reply ready in their hand.
No, my lord, the
not
Wakalatnama, not the reply, my lord.
Just the Wakalatnama.
Yes, my lord, there's no direction to affidavits. I'm only praying for recording my undertaking.
He's saying that the Wakalatnama has not been stamp punched, my lord.
Only that.
Not stamp punched. That he is seeking an undertaking. No. He's seeking an undertaking to file it during the course of the day, my lord. My lord, kindly takes, my lord, page, my lord, 23. This is, my lord, my agreement. My lord, this is a kind of a supply chain finance agreement, my lord. Here, my lord, kindly, if your lordship takes 23, at the top, lordship will find, my lord, clause B.
Clause B.
Yes, my lord, clause B at the top.
In the course of
yes, my lord. In the course of business, supply, sales, goods and or render services of various customers, including the borrower from time to time, and raises invoices containing particulars of goods supplied and amounts due under such invoices in accordance with the terms of the agreement between the principal and the borrower. Now, my learned friends' clients are the borrower. I'll show it, my lord. Then C, my lord. The lender and the principal have an arrangement in terms of which the principal has inter alia agreed to indemnify, as I was saying, my lord, and recommend buyers from its network to the lender for the purpose of short-term financing from the lender. The lender will provide the facility to the borrower, which money shall be considered as payment towards purchase of goods from the principal. Relying upon the representation and information provided by the borrower to this agreement, the lender has agreed to grant the facility to the borrower in terms and conditions hereinafter. So, my lord, the arrangement is such, he would, my lord, bring in buyers with invoices. He does not have the purchasing power to, my lord, pay then for his goods and services. I would give the money, and thereafter he would, my lord, pay me, my lord, and I earn a nominal interest out of the same. Now, my lord, there is a period which
You are the lender.
I am the lender, he is the borrower.
Who's the principal?
He Vedanta, my lord. The principal, my lord, here, my lord, is the invoice provider. My lord, that would be, my lord, a more, my lord, appropriate way of saying. Now, my lord, he does not have the purchasing power. So, my lord, money is provided by me for a period of 90 days within which he is supposed to pay me back. If not, then it causes a default, my lord. Now, my lord, that, my lord, lordship will find. Kindly sees, my lord, page 24, clause, my lord, 5.1 towards the middle, my lord.
Yes.
Repayment. The borrower shall completely repay the relevant tranche. So, my lord, the agreement is one. There are several tranches. From time to time, as and when invoices come, I am to pay in tranches to him the amount. So, my lord, kindly sees the borrower shall completely repay the relevant tranche of the facility along with applicable interest, cost and charges as a bullet payment on the last day of the tenure unless extended by the lender at its sole discretion. Now, my lord, the only way that my learned friend can come out of this is to show that I have extended the period of 90 days, which I have not done, my lord. I'll show it. Now, my lord, kindly sees in the event 5.2, the borrower fails to repay the outstanding amount into the designated account on the last day of the tenure, the borrower shall be liable to deposit all the outstanding amount into the designated amount no later than 1 business day from the expiry of the tenure. It is clarified that no notice or reminder shall be given by the lender to the borrower to repay the facility as per the agreed terms timelines. So, my lord, I don't need to. In other cases, I have to terminate, my lord, make a demand notice. Here, my lord, I don't need to, because that timeline, my lord, if it expires, I am entitled, my lord, to the entire amount. That's, my lord, the agreement between the parties. And, my lord, kindly sees 5.3, which is very important. The records maintained by the lender, that is, my lord, lender is myself, in its ordinary course of business shall be conclusive evidence for the due amounts from the borrower in respect of the facility. So, lordship, my lord, prima facie, if I can show, my lord, from my records that amount are due, that is the end all. My lord, thereafter, I don't want to show anything, because that's the, my lord, conclusive evidence, my lord, accepted by them. Now, my lord, kindly sees what would cause a default. That's, my lord, page 25, clause 10. Events of default and consequences. Occurrence of any of one or more of the following shall be treated as an event of default. Now, my lord, kindly takes A itself. Failure by the borrower to repay the outstanding amount on the last day of the tenure or before the expiry of the extended repayment period. That is, my lord, is termed as a failure or a default. So, my lord, I will go under A, not the other clauses, because there is a default of the outstanding amount. Now, my lord, apropos this, before I take my lord to the documents, kindly sees the arbitration clause.
Like there was no extended repayment.
There is no extended period, my lord. I have not extended.
Last day of the tenure.
Yes. Now, my lord, kindly takes page 26 before I take my lord to the records. My lord, the governing law and the arbitration clause, which, my lord, gives my right to come before my lord. My lord, 15.15, 15.1. This agreement shall be construed in accordance with the laws of India and subject to the arbitration clause below, shall be subject to exclusive jurisdiction of the competent court situated in Kolkata. So, my lord, therefore, there is no difficulty in, my lord, the jurisdiction as far as concerned, it is before, my lord. Then 15.2, my lord, in the event of any dispute or difference between the parties under this agreement, including in relation to the construction or interpretation of this agreement, or as to the rights, liabilities, parties arising out of this agreement, the dispute or difference shall be resolved through arbitration, which shall be administered by an institution. My lord, this is for the appointment. We are not getting into it. Lordship takes the last sentence. The arbitral award shall be final and binding on the parties. The seat and venue of arbitration shall be at Kolkata. So therefore, my lord, the jurisdiction is conferred upon my lord. There cannot be any dispute to that. The jurisdiction clause as well as seat and venue agreed by the parties. Now, my lord, kindly sees, my lord, what has happened, my lord. My lord, apropos this agreement, there was, my lord, a default which had occurred earlier under this agreement in other tranches. So we came up in a Section 9 application before this honorable court. This honorable court, my lord, by an order under Section 9 at that point of time, my lord, refused to give an interim order because, my lord, under that tranche, my lord, it was seen that the payment was made. My lord, that lordship will find the order we have enclosed, my lord, page 117, my lord, in the second volume, my lord. My lord, kindly sees this order of 12th November 2024 passed by this court in the earlier Section 9 application. Now, my lord, kindly sees this is an application under Section 9 of the Arbitration and Conciliation Act 1996 for injunction in terms of prayers, my lord. The prayers have been quoted. Now, my lord, kindly takes, my lord, page 118. My lord, kindly takes the second paragraph. Mr. Such and such for the petitioner draws the attention of the court to the loan sanction letter, July 25, 2023, and submits that the facility amount of rupees 2 crore having a tenure of 12 months with the tenure of 90 days for each tranche. My lord, this is followed, I'll show, was sanctioned in favor of the petitioner. Page such and such of the application contains the schedule of terms. Reliance has been placed on the said terms. It is submitted that irrespective of the fact that Vedanta Limited was the principal of the borrower, which lordship asked, my lord. In this case, now, my lord, the principal is Gupta Electricals, I think, my lord, Gupta Power. The respondents were treated to be borrowers all along and were liable to repay the amount as per the schedule. The recall notice has been placed in detail to show an amount of 2 crores and odd was due and payable by the respondents against the loan account 0481. This is the loan account, my lord. Now, my lord, kindly sees there, my lord, submission was that my lord, the entire amount has been paid under that tranche. My lord, that lordship will find at page 120, second paragraph. Mr. Such and such, learned advocate for the respondent number 1, draws attention to the court to page 9 of the affidavit in opposition. The same is an email dated 24th April 2024. The email was written by the representative of the lender, that's my officers, my lord, in respect of the loan account, same loan account 0481. Mr. Such and such contention is that the email clearly indicates that the principal amount was no longer due, but only interest of 22,000 was due and payable. The principal amount was shown as INR 0. Reference was further made to the document at page 10, which showed the loan details, that is sanction of 2 crores against an application of 15800 disbursed on 1st August 2023. Pages 14 and 15 have been relied upon to show that the application under 15800 payments to the tune of 25 crores on 3 occasions, rupees 24 crores 50,000, 24 lakhs 50,000 on one occasion, and finally 1,50,000 on the last occasion were made. Mr. Such and such refers to the disbursement made by the lender upon receipt of such payment and submits that those disbursements were in relation to other agreements and or transactions, which I'll show, my lord, is incorrect. The money was sent to the account of the respondent number 1 directly and not through Vedanta. They were not part of the loan agreement, which is the subject matter of the proceeding. Now, my lord, kindly skips this and comes to the, my lord, finding which is her ladyship has made. Kindly comes to, my lord, page, my lord, 123. My lord, this is the cause of action before my lord. Thus, the respondent number 1 has made out a case of restructuring of the loan account, if not a case of payment of the entire outstanding. There is clear admission of such restructuring by the petitioner's officer. My lord, I agree to it. The restructuring took place admittedly after the application under section 9 had been filed. That's the earlier application. Fresh payments, my lord, this is very important. Fresh payments, disbursements were made by the lender on 23rd March 2024, 26th March 2024, 27th March 2024, 28th March 2024, and 10th April 2024. And this is my cause of action today before my lord. The contention of Mr. Banerjee that the tenure for repayment of loan account of 2 crore 8 lakhs in order expired in July 2024 and the respondents were sitting tight over the matter without payment of the single farthing has not been established. That's, my lord, the earlier payment. I'll show it. Now, my lord, kindly sees the argument advanced by Mr. Such and Such at question of trial before the arbitrator at the time of consideration of prima facie case, balance of convenience and inconvenience and irreparable loss and injury. A mini trial is not required to be held by court. Whether the money is disbursed on the above dates after restructuring have been repaid or not is not an issue before this court in the earlier section 9. The lender may also proceed according to law against such outstanding. So today I have come before my lord accordingly in terms of this, my lord. As of now, the prayer of injunction has not been restricted to the subject matter of agreement which has been annexed to this application. From the records and the admissions made by the lender that the restructuring was done at the request of the respondent number 1, the court does not deem it either fit or necessary to grant injunction. Prayer D. Subsequent events have taken into account. The pleadings are not. Because, my lord, at that point of time, my lord, I did not have, my lord, these pleadings, my lord, which are payments made post the section 9 being filed. Now, my lord, kindly sees why I say this and why it is apparent from the records. Let me first, my lord, show from the respondent's affidavit in reply, affidavit in opposition filed in the earlier section 9. This proves the case on the face of it. My lord, will kindly come to page, my lord, 82 of the first volume. This is part of the affidavit in opposition filed in the earlier section 9. So I have annexed it before my lord. Page 82, my lord, is a letter given by the respondent number 1.
Affidavit in opposition starts from page.
My lord, affidavit in opposition.
Just showing the letter. Are you showing the letter or the affidavit?
No, I'm showing the letter, my lord, at page 82. This is, it starts at page 62, my lord. Page 67. My lord, there, let me show it from there first. Their opposition starts from page 59. And my lord, from their annexure kindly comes to, my lord, page 67. This was the mail that they showed at the earlier section 9 stage, by which they said that the earlier 2 crores has been paid, so no injunction should be passed at that stage. Now, my lord, kindly takes page 67. This is part of their opposition. Messrs. Such and such, greetings. Ugro, this is regarding your loan 0481. Your account is due for an amount of 22,000 and odd. Dues comprises of principal INR 0, as my lord recorded in that judgment or order. Interest of 22,000 and odd. We request you to kindly clear your dues immediately to maintain the good credit history and avoid levying of additional charges. So, my lord, by this, they were able to establish before this court that the earlier 2 crores was paid and 22,000 was only due under the tranche. Now, my lord, kindly comes to, this is very important, page 68. Lordship will find at the top the loan account number. This is the loan account number, my lord, under which there are tranches 0481. Lordship has got it, my lord. And kindly mark the date, my lord. This is of 1st of April 2024. Very important, my lord. Now, my lord, this statement, which has been relied by them, kindly come to, my lord, page 73. Here, my lord, firstly comes, my lord, at the middle of it, Lordship will find, my lord, the number 15800. Lordship has found, my lord. Lordship has got it, my lord. Now, my lord sees 2 crores. 1/8/2023, the loan date, 0 interest, 0 principal, my lord, and they have paid the entire amount. Close due date, my lord, was 31/3/2024.
15800 is 3. There are 3 of them.
No, my lord, at the middle, lordship will get 15800. There is
This
1.
is okay.
L1, my lord.
L1.
This was the dispute in the earlier section 9,
Yes.
which, my lord, resulted in that the court said that this has been paid, so interim order should not be passed. Now, my lord, this is 2 crores. Loan date is 1/8/2023. Then, my lord, kindly sees no principal due, 0, interest 0, penal interest 0, paid principal 2 crores. Then, my lord, the date was 31/3/2024. The cause of action before my lord is just the, my lord, portion just at the top of it. Lordship has got, my lord, 52533.
Yes.
These are the 4 that they are showing. Actually, it should be 5. Why I'll show it. These 5 entries, my lord, amounting to, my lord, 24,98,000, 24,50,000, 24,98,000, 24,98,000. Kindly sees the date. Loan dates are, my lord, 23rd March 2024, 26th March 2024, 27th March 2024, and 28th March 2024. And that is why the court rightly held against me that, my lord, these are post section 9. This cannot be the cause of action in the earlier section. Now, my lord, kindly sees the due dates at the right hand side, my lord, extreme right. These are the 90 days due dates. 21st June 2024, long gone. 24th June 2024, long gone. 25th June 2024, long gone. And 26th June 2024. Now, my lord, they don't have the 5th entry. Why? Because, as I said, the statement date is 1/4/2024. Now, when I file my reply in the earlier application, my lord, I have annexed the same statement. Kindly will, my lord, see page, my lord, 83. Now, my lord, kindly will see at the top at page 83. Lordship has got it, my lord?
Yes.
My lord, at the top, lordship will find the same loan account number 0481.
Yes.
And kindly now mark, my lord, the date of the statement 27/8/2024. So this is post April, my lord. Now, my lord, kindly comes to the same page, my lord, which, my lord, they have relied upon. And I'll show it to my lord. Kindly comes to, my lord, page 101. Now, my lord, kindly sees 101. The second box is the same, my lord, recording 158,000, 2 crores, loan date 1/8/2023, principal amount 0, interest 0, penal interest 0, amount paid on of 2 crores. Then, my lord, 31/3/2024. Lordship has got it, my lord. Just above that, same entries as I showed to my lord, 2533. 24,98,000, 23rd March 2024, 24,50,000, 26 March 2024, 24,98,000, 27th March
These
2024.
have been considered by the.
No, they have not. Lordship, in that judgment, the court holds that these are subsequent payments. You may have a cause of action, but not in that section 9. Now, this is why I have to file a fresh section 9 before, my lord. And the 5th entry, my lord, kindly sees a 1 crore. That's 10th of April 2024. Since that statement was of 1st April, this entry would not be there. This is of 10th April 2024. And the due dates, my lord, all have expired at the right-hand side, my lord. The last even being 9th of July 2024. Now, today my claim, my lord, is before my lord, is kindly sees before that they themselves have forwarded these, my lord, invoices at page 102. This is their mail from Bharat Electricals Accessories Private Limited, subject repayment request, attachments, my lord, and the invoices are here, my lord. They are rounded because here, lordship will find 24,98,000 and all. There are 7 invoices or 8 invoices, out of which I have paid only 5 because the discretion is with me. Now, my lord, kindly sees, my lord, apropos this, the agreement ones, because, my lord, the limit was 2 crores, so I cannot exceed that. Page 35. Page 35, my lord. Bharat Electricals, my lord, is the borrower. That's the respondent number 1 before, my lord. And the rest of them are co-applicants at page 35, my lord, in the agreement. Now, my lord, kindly sees the facility amount is 2 crore. So, my lord, I can't give more than that. That's the limit, my lord, although the invoices are more than that. And, my lord, the tenure of each
But the
tranche,
first agreement which you have shown me,
this is a continuation of that, my lord. The same agreement, my lord.
no, but how can the borrower change?
No, the borrower has not changed. Borrower is Bharat Electricals. That's principal. Principal will change, my lord. Borrower
Principal
is the
was
same.
Vedanta at that time, and now it's Gupta.
Gupta, yes. Borrower has never changed. Borrower are the same, my lord. Now, my lord, facility amount is 2 crores. I cannot exceed that, although he has given 8, my lord, invoices which are more than 2 crores. And kindly see his tenure of each tranche is 90 days. So, my lord, what they are trying to do, they are saying that this is a separate agreement. Tranche is not a separate agreement. Tranche is part of the same agreement. That is why I showed, my lord, the agreement number and the tranche numbers. This 90 days, my lord, has expired. And, my lord, apropos that, they have also, my lord, written a letter to us, which is, my lord, is at page 82. Requesting us, my lord, that they are not in good my lord, financial status. Kindly sees page 82, given by Bharat Electricals Limited, 19th of March 2024, page 82, my lord. This is post the section 9 application, my lord, which was filed. 19th of March 2024.
But how are you relating it to the earlier loan agreement?
No, there is one loan agreement. There are several tranches.
Tranches, right.
The first tranche, my lord, I filed a section 9, which was disallowed correctly because they had paid up. But these 4 tranches are post the section 9, which was filed, which was held in the earlier judgment, could not have been the cause of action in the earlier, my lord. It has to have come, I have to come up with a fresh section 9, and that's before, my lord.
No, but are these also the part of the same
Same loan agreement? That is why, my lord, I showed, if your lordship kindly takes the next page itself, page 83, the statement, loan agreement number is 0481 at the top. Same, my lord. I was showing page 82, next page, page 83. Kindly sees the loan agreement number 0481. Lordship has got it at the top. So loan agreement number remains the same. The statement that they have filed and what my lord, I have filed in my reply as the same. 2481. And the tranches, my lord, have a separate number, which lordship will come to 101. And there is, I think, my lord, 73. Same. The tranche numbers are, kindly sees 101. Second column, my lord, tranche loan number. Lordship has got, my lord, page 101. Second column, my lord, is tranche loan number.
Yes.
Now, my lord, every invoice that he gives, I give him a new tranche number, but the loan number remains the same. This is the statement under the same loan number. Sees, my lord, 101 and compares it, my lord, with their affidavit in reply. They have also enclosed the same, my lord, page 73. 101 and page 73, my lord, are the same. Only that his, my lord, is 1st of April statement, so will not have the 5th entry, while mine is of July, so it will have the 5th entry also. So the second column, my lord, is tranche, my lord. Tranche loan number. Now, tranche will change because each invoice will have a tranche. And that is exactly what is trying to, my lord, misguide by saying that this is a new loan agreement. No. Loan agreement is the same because the statement at the first page of his and mine shows the same number 0481. Tranche numbers will change. Now, my lord, under these tranches, he has not paid back within the 90 days period. Now, if your lordship now comes back to page 82 once, my lord, his is mail to me from the respondent number 1, Bharat Electricals, dated, kindly sees the date, my lord, 19th of March 2024. As per our discussion, we want to regularize the account in multiple tranches of payments with 25 lakh each. So he agrees that, my lord, the agreement is one, there are multiple tranches. We sincerely request you to waive off the interest amount. Also, it was discussed that no amount will get held or deducted from your side. You all are supported a lot and requesting to extend the same amount to this current situation to us. Within the next few days, with all your support, would you be able to regularize the account? So, my lord, they accept my lord, default, and they say that they'll regularize it. We are also trying to revive our unit with our best efforts, and hopefully in the coming days, we will be able to start the manufacturing process as well. We thereby need your support in this regard to revive our unit in the best possible way. Kindly waive off the interest amount, and a line of confirmation to the above will be very helpful for us. So, my lord, all that they ask for is a waiver of interest. Nothing more than that. They accept, my lord, the amount that is due and payable. Now, my lord, apropos this, my lord, in view of this prima facie case being made out, my lord, what they did was, before this, the co-applicants tried a new, my lord, method. They filed a suit before this honorable court, saying that the my lord, applicant, the borrower, has, my lord, forged the signature, and, my lord, filed a suit. We appeared there, filed a section 8, and, my lord, the judgment I have enclosed, which starts from, my lord, page 161 of the honorable suit court, my lord, taking up the commercial suit matters, my lord, 161, has categorically held there is no appeal against this order, my lord. There is no order of stay against this judgment, whereby, my lord, the court has held that the disputes, if any, under the same agreement are arbitrable. And, my lord, kindly takes, my lord, page 174. Considering the above, this court finds that the disputes raised by the plaintiffs, that's, my lord, the co-applicants, respondent number 2 onwards, are duly covered under clause 15.2, the clause I showed, of the facility agreement. Thus, the parties to a suit are referred to arbitration.
My lord, may I offer a factual correction here, my lord? In fact, appeal had been preferred to the Supreme Court from this. Notice has been issued. On the
I have not
aspect of
complete. I'll come to
only
that.
saying that
My lord,
because
let me
from that
complete.
my lord,
Now, my lord, therefore, this has been referred to arbitration. Now, my lord, kindly sees, before the Supreme Court, I intentionally got a copy of the SLP because they'll try to stall the proceeding before, my lord. No, that should be the. I think this is the copy I'll give to them also, because kindly sees, my lord, who is the, my lord, petitioner before the Supreme Court. Respondent number 1 is not. He is just like, my lord, a respondent, as I am being described therein. My lord, kindly will see the cause title. Cause title page to roll it through. Give me one moment, my lord. I'll just take out the cause title. Yes, kindly comes to, my lord, page 16. Page 16, my lord, of the SLP, my lord. My lord, kindly seeks 3. Respondent against whom I'm seeking this order is a respondent. So, though SLP filed by the respondent against that order, my lord, this proceeding is maintained. It can't be stalled by him at least. Now, my lord, kindly sees it's respondent numbers 2 to 4 who have filed the SLP. My lord, will see the cause title, which is, my lord, at page 15. That's, my lord, 1, 2, and 3. So, there is no SLP. And there is, my lord, no order issue notice as far as the respondent number 3 is concerned, or the respondent number 1 herein before, my lord. So that is why I say, my lord, there is no appeal as far as the respondent number 1 against whom I am seeking an order, my lord, for the my lord, accounts not to be, my lord, dealt with, has no proceedings, my lord, against these, my lord, accounts or anything. Now, my lord, kindly sees, apropos this, an order was passed to issue notice. There is no stay, to issue notice. Well, that is with regard to the suit. So, my lord, that is with regard to respondent numbers 2 to, my lord, the rest of them. Now, my lord, what I am seeking, my lord, is before, my lord, apropos the prima facie case that I have made out, my lord, today, which is the subject matter of the present section 9 application, as, my lord, held by the earlier section 9 order also, that this we have to file a fresh section 9, is that, my lord, it is really My lord, prayer E, my lord, kindly comes to page 19. This is all that I'm asking. Page 19 of my petition. This is all that I'm asking for. Injunction, my lord, restraining the respondents, their men and agents from withdrawing any amount, any money from bank accounts more fully mentioned in annexure H hereof without keeping aside 2 crores 93 lakhs. And my lord, annexure H, lordship will find, my lord, in my second volume, my lord, page 176, I have given the details of his bank accounts, which is at page 176, annexure H. He has 2 bank accounts, one with Punjab National Bank. Again, respondent number 1, 224, I have not sought any orders. And kindly sees, my lord, 2 accounts which Punjab National Bank, which he has. I have given the, my lord, IFC code and the account number details also. So all that I am seeking, my lord, is, my lord, an injunction not to deal with it without keeping 293. I'm not saying, my lord, not to deal with the account. I'm allowing him to deal, but without keeping 293, which is my amount due and pay, my lord, which is due to me, my lord, under the agreement, and 90 days has passed. Or if your lordship wants, I can show, my lord, the Mittal judgment, my lord, that lordship is, I'm entitled to an order of injunction, my lord. But, my lord, I'm not showing it. If he wants, then I'll show, my lord. My lord, I want, my lord, an order, interim order to this extent today.
Senior friend starts on the point of responding numbers 4 to 6 are the petitioners before the Supreme Court. One factual submission only.
Why you are appearing?
Look at the Supreme Order.
Why you are appearing for?
I'm appearing only for the responding numbers 4 to 6, who are the petitioners before the Supreme Court. Where we'll see the last line of that, or there is a stay on the judgment passed by this order. I distributed my signatures on the loan agreement and sought to avoid it, and that is still pending. Or we'll see the last line of that.
So 2, I'm not seeking any orders against them.
4 to 6.
No, but 4 to 6 will also be part of those tranches.
No, 4 to 6, my lord, will be part of the arbitration proceeding either if it is held in favor against them. If not, my lord, they won't be.
No.
I am against, they're co-applicant.
Co-op.
Co-applicant. So their, my lord, right would only appear if he fails.
No, whatever it is.
So respondent number 1, I am seeking, and kindly sees my prayer, my lord. That is why I have been very cautious. I am not seeking any reliefs against the co-applicants. I am only seeking reliefs today. I am cautious about this, my lord, order of the Supreme Court. I am only seeking relief against respondent number 1's account, which 224 cannot, my lord, stand in the way. My prayer is very specific. Kindly sees prayer E. Once, my lord, injunction, respondent such and such withdrawing these 2 accounts, as, my lord, I have given the details in annexure H, belongs to only respondent number 1. Because I don't want, my lord, any reliefs under 224. I'm conscious about that. This shows, my lord, they're hand in gloves, my lord, the consultation here.
They should be hand in glove. Yes.
Anyway, my lord, I'm not into that.
Borrowers,
I'm only, my lord, happy with the
applicants.
But, my lord, the pleadings before the, my lord, the suit court is otherwise.
It is otherwise that
Otherwise.
is closed.
Yes.
We don't know each other.
May I respond, my lord? My lord, the Supreme Court in Rahul S. Shah, the division bench of this honorable court in Harleen Jarath have all said that, my lord, attachment before judgment. Now, the principles under AIR 1951, Calcutta, have been relaxed to the extent that if you have an unimpeachable case, you can ask the court to secure the amount that you are claiming in the arbitration or in the suit, respectively. Here, my lord, your lordship will therefore have to see whether an unimpeachable case has been made before your lordship. My lord, I would like to rely on one judgment of the coordinate bench of this honorable court.
Don't you think you should deal with the facts? And
I
then
shall. Or this judgment only to say, my lord, that the relief of attachment before judgment cannot be granted ordinarily before affidavits are invited. And here, my lord, this is the second round, as my learned senior friend has rightly pointed out. So, my lord, may I draw your lordship's kind attention to the order passed in the earlier section and application, which very accurately recounts the facts, my lord, with page numbers referred to in the pleadings. If your lordship will kindly take page 117. What was the case that we came to the honorable court with? Kindly see page 117.
Should I see this judgment or what you're showing?
The judgment of the...
This one?
No, my lord. Kindly see the
Justice
judge.
Sharkar.
Yes, my lord. Justice Sharkar's judgment at page 79, my lord, of the second volume. There are 2 page numbers, my lord. 117 and 79 are written. I think 117 is the correct page number. That is on top.
But
Your
the
lordship,
reason why it was not granted is because they had already, the loan was paid off and only the interest of some 22,000 odd
no,
amount.
my lord,
was
it's not
left.
that simple. There's a little more to it. Lordship will kindly see I will take your lordship through the loan agreement first. What does the loan agreement contemplate? It is a supply chain facility. What does that mean? There is a principle by the name of Vedanta. Let me start from there then. Take your lordship through the first facts then. Principle by the name of Vedanta. Vedanta is to raise an invoice on me, and the disbursement by the lender, the petitioner's client, will go directly to Vedanta. Let me start from there then, my lord. Kindly see the agreement which starts at, my lord, page 23.
Yes.
I am only trying to show your lordship, my lord, this already has been considered by the honorable court, my lord, and here there is a case of
Take your
restructuring.
time, show me everything.
Yes,
I'm
very
in
well.
no
my lord.
hurry.
Very well. Kindly take page 23. Your lordship has seen, my lord, clauses A to D. For completeness, may I show your lordship that again?
Whatever you want to show, just take your time, show it to me.
Very well. Very well. If your lordship will kindly see, I am named as the borrower, Gupta, my lord, Bharat Electric. A lender being a
Where you're
page 23, my lord. I'm inviting your
Uh,
lordship's kind attention.
you're reading A,
Yes, my lord. B, your lordship is that they are an NBFC
right?
registered
B
non.
you are reading. B you are reading.
B, I'm reading. Yes, my lord. A, if your lordship will also note, they are an NBFC, they say. I have a point of maintainability on that also I will come to. B is in the course of its business hereinafter referred to as the principal. Supplies, sell goods and or renders service to various customers, including borrower from time to time, and raises invoices containing particulars of goods supplied and amounts due under such invoices in accordance with the terms and agreements between the principal and the borrower. The lender and the principal have an arrangement in terms of which the principal has inter alia agreed to indemnify and
To identify and recommend.
identify and recommend, yes, buyers from its network to the lender for the purpose of short-term financing from the lender. The lender will provide the facility defined below to the borrower, which money shall be considered as payment towards the purchase of goods from the principal. Relying upon the representations and information provided by the borrower in this regard, the lender has agreed to grant the facility to the borrower on the terms and conditions hereinafter mentioned. Thereafter, my lord, may I invite your lordship's kind attention to clause 3 at page 24. This is very important. Disbursement of facility.
Yes.
Subject to the terms of the facility documents, the borrower shall be entitled to submit a disbursement request for each facility to the lender. The disbursement request shall be issued by the borrower no later than 1 business day prior to the proposed date of disbursement. Kindly note the next line, 3.2. Disbursement of the facility shall be made by the lender into the account of the principal as per the mode of disbursement set out in the schedule 2. Disbursement does not come into my bank account. Disbursement comes into the account of the principal. Who is the principal? Lordship will kindly see at page 29 is the schedule. Kindly see the schedule at page 29, my lord. Schedule 2. Serial number 1 in the schedule, my lord. Details of borrower, Bharat Electric. That is my client. Serial number 3. Details of the principal, Vedanta. So, my lord, disbursement does not come into my account at all. Disbursement comes into the account of Vedanta under the terms of this agreement. So, my lord, my humble submission will be, when I show your lordship the accounts and my lord, the loan statement, that any disbursement that is made directly into my bank account or into the bank account of anybody else, Gupta Power or any other third party, not the principal Vedanta name in this agreement, has no relationship or bearing with the disputes that arise out of this arbitration agreement. So they are unrelated to this arbitration agreement, my lord. Section 9 petition is for interim relief in aid of the final relief sought in arbitration proceedings invoked under the arbitration agreement contained in this loan agreement. Any disbursement made either directly to Bharat Electric, the respondent before your lordship, or to any other third party other than Vedanta has no relationship or bearing to the arbitration agreement in respect of which, my lord, this section 9 has been filed. Next, my lord. Now, my lord, may I show your lordship directly the judgment in the earlier section 9 order, page 170. Kindly see. I will have to place this.
Just one. Yes.
Please, my lord, I will have to place a little exhaustively, my lord. I will request your lordship to kindly bear with me while I show your lordship the submissions also that I had made before the court, my lord.
You show me everything which you want to show.
Yes, my lord. My lord will kindly see. It was the petitioner's case, my lord, that 2 crore odd was due and owing to it under the agreement. My submissions, my lord, are recorded at page 120 onwards. Internal page 4, my lord.
Yes.
Second paragraph.
Yes.
Advocate for the respondent number 1 draws the attention of the court to page 9 of the affidavit in opposition. The same is an email dated 24th April 2024. Email was written by the representative of the lender in respect of loan account such and such. Kindly note the number of the loan account, my lord. This is important. Last 4 digits are 0481.
Yes.
Contention is that the email clearly indicates that the principal was no longer due, but only interest of rupees 22373 was due and payable. Principal amount was shown as INR 0. Reference was further made to the documents at page 10, which showed loan details, that is sanction of 2 crores against application number 15800. Kindly note this also, my lord. This is also very important. So, my lord, the loan account number is referred to ending in 0481, and the application number 15800 is also recorded. Why the application number is relevant, my lord, is the loan statement that is disclosed at page 73 onwards, my lord, that bears reference to the application number. So disbursements are made against the application number. If your lordship will kindly, my lord, allow me to continue placing this order. So I was reading, the principal amount was shown as INR 0. Reference was further made to the document at page 10, which showed the loan details, that is sanction of rupees 2 crores against application number 15800, disbursed on 1st August 2023. So single tranche disbursement. Page 14 and 15 have been relied upon to show that against the application number 15800, payment to the tune of 25 crores on 3 occasions and 24 crore 50 lakhs on one occasion, 50,000 on one occasion, and finally 1 crore 50 lakh on the last occasion were made. Further submits refers to the disbursement made by the lender upon receipt of such payment and submits that, kindly note this, my lord, this is my submission then and now, that the disbursements were in relation to other agreements and or transactions. The money was sent to the account of the respondent number 1 directly and not through Vedanta. They were not a party of the loan agreement, which is the subject matter of this proceeding. Those were separate loan facilities and not the subject matter of the arbitration agreement. Reference has also been made to page 15 of the opposition to show the statements and monthly interest status. The loan status against the application number 15800 depicted the same as closed, indicating that neither any interest nor any principal was payable. The closure was dated 31st March 2024. These documents relied upon by the respondent number 1 belong to the lender. They were annexed to the opposition to establish how the transactions were going on and further establish that the amount disbursed by the lender on 1st August 2023 pertained to the invoice of Vedanta dated 31st July 2023, which was the subject matter of the recall notice, had been paid back. It is the contention of the respondent number 1 that subsequent payments to the bank was on account of restructurization and not part of the agreement out of which the dispute has arisen. So, my lord, thereafter, if your lordship will come to the holding, that is from page 122, my lord. The question is whether the injunction as prayed for in this application should be allowed. From the affidavit and reply filed by the litigation manager of the petitioner, it appears that there is an admission with regard to payment claimed to have been made by the respondent number 1. The averments narrate that during the pendency of the application under section 9, the petitioner was approached by the respondent for reschedulement of the account by an email dated 19th March 2024. This is the email on which Mr. Banerjee has placed reliance upon. In view of the request, the account of the respondent were restructured by the petitioner. Reference has been made in this regard to the document at page 9 of the affidavit in reply. The same is an email dated 24th April 2024 written by the lender to the borrower, indicating that only interest amount of 22,373 was due. The documents at page 10 to 15 were statements annexed to the said email which indicated restructuring. It has also been admitted by the deponent that amount of 2 crores which was paid on 1st August 2023 and is the subject matter of the arbitration agreement, as also the recall notice, had been restructured. Paragraphs 3 and 4 of the affidavit in reply clearly indicate so. It has been stated in paragraph 5 that after the restructuring, further financial assistance was given to the respondent and fresh tranches were created in terms of the restructuring request by the respondent. Now, my lord, here I will pause, and my lord, my submission in this regard is the restructuring was not only of the loan account, my lord, ending in the number 0481. There are other transactions between the parties. So, my lord, the restructuring is a global settlement that was, my lord, trying to be achieved. So, my lord, the further disbursements that are made directly either into the account of the respondent before your lordship or into the account of Gupta Power or other related entities. These are not, my lord, disbursements made under this loan agreement, which categorically mentions that disbursement is to be made directly to the principal, namely Vedanta, whose name is recorded in Schedule 2 of the loan agreement. So, my lord, this has no reference to the loan agreement in respect of which, my lord, Section 9 is being filed. Now, my lord, may I show your lordship? Thereafter, page 123 also, my lord. I beg your pardon. The petition is relying on the last sentence at page 122 of the order. The disbursement dates have been mentioned at page 5. The loan account number is the same. The invoices have been mentioned along with the disbursement dates, which tally with the documents annexed by the respondent number 1 in the affidavit in opposition. So, my lord, they say that these are these further disbursements on the basis of which the due now, the present cause of action arises, my lord. And, my lord, the invoices are also referred to here. Invoices are at Annexure D to the present petition. I'll take your lordship through them. Then, my lord, there is a finding at page 123, second paragraph. Thus, the respondent has made out a case of restructuring of the loan accounts, if not a case of payment of the entire outstanding. There is a clear admission of such restructuring by the petitioner's officer. The restructuring took place admittedly after the application under Section 9 has been filed. Here, my lord, the dates on which fresh disbursements are made are recorded. Fresh payments or disbursements were made by the lender on 23rd March 2024, 26th March 2024, 27th March 24, 28th March 24, and 10th April 24. The contention of the petitioner that the tenure for repayment of the loan amount of 2,08,19,871 has expired in July 2024 and the respondents were sitting tight over the matter without payment of a single farthing has not been established. The argument advanced by the petitioner also questions of trial before the learned arbitrator. At the time of consideration of prima facie case, balance of convenience and inconceivable irreparable loss and injury, a mini trial is not required to be held by the court. Whether the money disbursed on the above dates after the restructuring have been paid or not is not an issue before this court. The lender may also proceed according to law against such outstandings. As of now, the prayer for injunction has to be restricted to the subject matter of the agreement which has been annexed to this application. From the records and the admissions made by the lender that the restructuring was done at the request of the respondent number 1, the court does not deem it either fit or necessary to grant an injunction in terms of prayer D. Subsequent events have been taken into account. The pleadings are not in such and such. So, my lord, this is the order. If there is a finding that there is a restructuring, the disbursement of 2 crores that was made under this loan agreement repaid in full. Further disbursement, my lord, whether they have been paid. So, further disbursements made pursuant to the restructuring, whether they have been repaid or not, this is a triable issue, my lord. Essentially, reconciliation of accounts will be required. Not only accounts under this agreement, but also, my lord, under other transactions between the parties, my lord. Because the further disbursements are made have no relationship or bearing with this loan agreement because they are not made to Vedanta. They are made either directly to the respondent or, my lord, to one Gupta Power. Now, my lord, may I invite your lordship's kind consideration to the documents which are referred to in this order, which were annexed by me in my affidavit in opposition to the first round of litigation. Lordship will find, my lord, from page 68 onwards, my lord. This is the annexure B to my opposition filed in the previous round. Or if your lordship will kindly see from 67, my lord, this is the petitioner's letter of 24th April 2024, acknowledging that the principal is 0, interest is, my lord, 22,373 only. Thereafter, if your lordship will kindly take page 68, my lord. Kindly see, my lord. This is a loan account statement at page 68.
Yes.
In the loan account statement, my lord, here your lordship will find the disbursements now on the basis of which the petitioner claims the present cause of action. That your lordship will find at page 72. If your lordship will kindly take page 72, my lord, serial numbers 283, or my lord, if your lordship will kindly see from serial number 281. Serial number 2. Beg your pardon, my lord, it's a little confused. Yes, 282, my lord.
283.
I'm sorry, if your lordship will kindly take from 281. 23rd March 2024, there is mention of the application number 15800. Then 23rd March 2024 again.
That's 282.
282, yes, I beg your pardon, my lord. My copy is not very clear, I apologize.
I think 283 would be the relevant
Yeah,
application
my lord,
number.
kindly allow me to place from 282.
Yes.
282 again, my lord. Paid against UGD 15800. Again, the application number is mentioned. Here, my lord, it is recorded 2 columns after that, 2.5 crores is paid. As recorded, my lord, in the earlier order just by Justice Sharkar, the coordinate bench. Then, if your lordship will kindly take 286. Again, 26th March 2024, my lord, paid against UGD application number 15800. So these are all disbursements made against the application number 15800. Again, my lord, 2.5 crores paid. Then, my lord, serial number 291. Again, my lord, 27th March 2024, paid against application number 15800. Again, my lord, 294, paid against 15800. So, my lord, all these payments, which I have repaid, these were payments made under the loan agreement, which is the subject matter before your lordship. All bearing application number 15800. Now, kindly see the transactions which are purportedly the cause of action in this instant petition before your lordship. Kindly take, my lord, 283, 23rd March 2024, application number UGD 52533. So the application number changes. There is a disbursement of
Which one are you showing?
283, my lord.
283.
Yes.
That's application number 52738.
283, my lord. 23rd March 2024, application.
233, yes.
Yes. So, my lord, the application number is different, under which a disbursement of 2 crore 49, how much is it? 24 lakh 98,000 is made. Thereafter, my lord, they have charged me penal interest on 25th March 2024. That is also on 25th March 2024. That is 284. Again, different. This is the same application number. Then again, if your lordship will see, my lord, 287. 26th March 2024. Again, my lord, application number is different. 52738. Disbursement of, my lord, 24,50,000. Again, next item, my lord, that is 288. Again, my lord, 26 March 2024, disbursement of 24,50,000 against application number 52738. Then, my lord, again, 292, 27 March 2024, application number 53031, payment of 24,98,000. Again, my lord, 295, 28th March 2024, application number 53506, disbursement of 24,98,000. So the application number has changed. That, my lord, reinforces my submission that these further disbursements that are being made post filing of the earlier round of Section 9, my lord, pursuant to the restructuring of the account, the admitted restructuring of account, these are not disbursements made under this loan agreement. These are disbursements made directly into the account of the respondent. That is not the contemplation of the loan agreement. Loan agreement envisages any disbursement to be made directly to Vedanta, because the supply chain facility, Vedanta will raise the invoice on me. Instead of payment to me, they will directly make the disbursement to Vedanta. So, my lord, this has nothing to do with this agreement. They are trying to bring this dispute within the fold of this Section 9. And lordship will kindly see, my lord, the order of the coordinate bench in the earlier Section 9 is dated 12th November 2024. My lord, 90 days from Section 9 disposal has long elapsed. They have not yet invoked arbitration. Section 21 notice not yet issued. Now they want the tribunal, the Honorable Court, to once again embark on a mini trial without exchange of affidavits at the ad interim stage and grant, my lord, attachment before a judgment, which, my lord, the coordinate bench in the matter of, my lord, Axis Finance, Sunil Kedia has said, ordinarily should be granted only after affidavits and without any unimpeachable case being showed, far from an unimpeachable case, my lord. Because even in the previous round, court found that there is a restructuring, any disbursements further to restructuring, whether they are the subject matter of this agreement or not, whether paid or not, is a triable issue. There's a categorical finding that whether the further disbursements are paid or not is a triable issue to be decided by the arbitrator. No appeal preferred from that order. Again, my lord, they invite this Honorable Court to revisit that same issue once again, which has already been considered by the court in the earlier round. Next, my lord. Another thing, my lord, may I show your lordship the invoices against which these further disbursements have been made, which your lordship will find from page 103 onwards. Kindly take page 103, my lord. It's a little unclear, but your lordship will find the name of the party raising the invoice very clearly.
Yes.
Invoice is raised by one Gupta Power Technologies Private Limited. On, my lord, the respondent before your lordship. He is admittedly not the principal named in the agreement. Kindly take the next invoice at page 104, again Gupta Power Technologies Private Limited. 105 Gupta Power Technologies Private Limited. 106 Gupta Power Technologies Private Limited, and so on. So these are not invoices raised by Vedanta. Pursuant to invoice raised by someone who is not named as the principal in the agreement, they are making disbursements directly into my account. Again, not envisaged in the agreement. So, my lord, any payment made to me directly into my account pursuant to these invoices, this is not the subject matter of this loan agreement and the arbitration clause contained in this loan agreement.
Yes, Mr.
Next aspect, my lord,
Anything
is
else?
yes, my lord, one or two things more. My lord, the petitioner has shown your lordship page 101 of the petition to
Yes.
show that the tranche changes, my lord, but the loan agreement does not change. Tranche may change, but the principal, my lord, named in the schedule of the loan agreement has not changed. There's no amendment. Only invoices raised by Vedanta can be paid by them directly, my lord, disbursement to Vedanta. That is the contemplation. My lord, even the arbitrator cannot rewrite the agreement between the parties. So at this juncture, there's no question of it, my lord. And next, my lord, again, my lord, this entirely becomes a triable issue at the ad interim stage without inviting affidavits. It's not possible to, my lord, either ascertain whether these, what is the settlement, whether the settlement is only in respect of account, my lord, 0481, whether the disbursements which suddenly take out a different application number, which, my lord, are against invoices raised by a different person not named as the principal in the loan agreement, whether they pertain to the same agreement or not, whether they have been repaid or not, which is admittedly held in the previous round to be a triable issue. From that observation or finding, there is no appeal. Next, my lord, another lordship will find that in the loan agreement itself, it is recorded that the petitioner is an NBFC, non-banking financial company. Now, my lord, there is a judgment of the Bombay High Court in Tata Motors versus Naushad Khan. May I please, that, my lord? Before I take your lordship to the judgment, my lord, gist of it is, if the petitioner or the lender here, my lord, who is seeking to recover the monies lent in advance, is a notified financial institution under the RDDB Act, Recovery of Debts Due to Banks and Financial Institutions Act, his remedy lies exclusively before the Debt Recovery Tribunal. Arbitration proceedings are not maintainable because Section 18 of the RDDB Act has a, my lord, ouster of jurisdiction clause. It says that, my lord, is a specialized forum created. So if you are a notified financial institution under the RDDB Act, then you must go before the DRT and not otherwise. This judgment also says that if you are a notified financial institution under the SARFACI Act, then arbitration is maintainable only for ascertainment or quantification of the amount outstanding. But, my lord, there can be no direction for payment. For recovery of payment, you once again have to go, my lord, before the Debt Recovery Tribunal, which is a specialized forum. So, my lord, I have not been able to ascertain whether they are, my lord, notified financial institution under the RDDB Act, but they will be a notified financial institution under the SARFACI Act. So, my lord, while arbitration proceeding in that case will be maintainable insofar as quantification of the amount outstanding, there can be no direction for payment in arbitration, and so there can also be no security, my lord, in aid of, my lord, what I'm trying to say, my lord, is that interim relief can be only in aid of final relief. Even arbitration proceeding instituted under this loan agreement, assuming, of course, the payments that they are claiming to have been made are pertain nexus with this agreement, there can be no direction for payment. So there can be no interim order at this stage, my lord, for securing these sums. They have to go before the Debt Recovery Tribunal, which is the specialized forum. May I place this judgment, my lord? Your lordship will kindly see from the beginning, my lord, the facts are important. The respondent in these proceedings have raised a fundamental objection regarding the jurisdiction of this court to entertain two petitions filed under Section 9 of the Arbitration and Conciliation Act 1996 and an application under Section 11 thereof, on the ground that the petitioner applicant in these proceedings is a financial institution covered under the provisions of the Securitization and Reconstruction of Financial Assets and Enforcement of Securities Interest Act 2002, further claiming that the petitioner ought to proceed under the SARFAESI Act and that the remedy of arbitration cannot be invoked by the petitioner at all. The respondents claim that the petitioner ought to approach the Debt Recovery Tribunal by invoking the provisions of the SARFAESI Act, and that the law laid down by the Supreme Court in the case of Vidya Drolia makes it amply clear that in the face of statutory remedy, which special tribunal available to the petitioner, resort to the arbitration proceedings is barred, notwithstanding an arbitration clause contained in the agreement executed between the parties. Brief reference to the facts would give the backdrop in which the present proceedings have been initiated. The petitioner had advanced loan facilities to the respondent for purchase of vehicles, and accordingly, loan cum hypothecation agreement were executed between the petitioner and respondents. Each of the agreements contain an arbitration clause. Now, my lord, may I invite your lordship to the findings from paragraph 9 onwards. The learned counsel further referred to the provisions of the Recovery of Debts and Bankruptcy Act, RDDB Act, particularly Section 2H thereof, which defines financial institution. Reference was also made to Section 18 of the RDDB Act, which specifies that no court or other authority shall be entitled to exercise jurisdiction in relation to the matters specified in Section 17 of the RDDB Act, such powers being exercised by the DRT. Then, my lord, if your lordship will kindly take from the next page of paragraph 10, my lord, third line. I need not, my lord, trouble you with the entire paragraph. The learned counsel for the respondent specifically relied upon the judgment of the Supreme Court in the case of Authorized Officer State Bank of India versus Alwyn Alloys Private Limited, Bank of Rajasthan, such and such. My lord, these judgments are considered. Paragraph 11. Also, Mantras Green Resources is considered. Then, my lord, holding is from paragraph 18 onwards. If your lordship will kindly take, my lord, paragraph 20 onwards. The relevant provisions of the RDDB Act are quoted. Definition, Section 2H, financial institution means 1. Public financial institution within the meaning of Section 4A of the Companies Act 1956. 1A, securitization company or reconstruction company, which has obtained a certificate of registration under subsection 4 of Section 3 of the Securitization and Reconstruction Financial Assets and Enforcement of Security Interests Act 2002. A debenture trustee registered with the board and appointed for secured debt securities. Such other institutions that the central government may having regard to its business activity in other area of its operation in India by notification specified.
It is
Then,
not that relevant for this purpose.
well, only that if they are a notified, my lord, financial institution under either the SARFAESI Act or the RDDB Act, my lord, their remedy, if at all, lies before the DRT, and they cannot, my lord, institute
You can
arbitration.
argue before the arbitrator.
My lord, but interim relief cannot be granted, which is the final relief, which in aid of final relief, which the arbitrator cannot consider. Is my submission to that effect only. And, my lord, there is also a notification of the RBI, my lord, which says that if your total exposure or lending is above 50 crores, my lord, you will be notified as a financial institution. So, my lord, in this in these circumstances, my lord, there is reasonable apprehension. They are in fact notified financial institutions. So, my lord, these are my submission that at this stage, my lord, ad interim, without inviting affidavits, my lord, whether these further disbursements are pursuant to restructuring or not, whether they bear any nexus with this loan agreement or not, because the application number is changed, invoices from third parties who are not the named principal, disbursement directly to the respondent, which is not the contemplation of the loan agreement. This cannot be decided here. These are tribal issues which have to be, my lord, determined by the arbitrator. No unimpeachable case made out, my lord. And, my lord, for completeness, I have handed up the judgment of the coordinate bench of this honorable court in Axis Finance, my lord. Paragraph 8. This considers, my lord, prayer for security by way of injunction under Order 39, Rule 1B, not Order 38, Rule 5, my lord, which is a stricter standard, says, my lord, ordinarily security can only be granted or should only be granted after inviting affidavits. If your lordship likes, I can place this judgment formally. Lordship is seeing it, my lord. May I just place paragraph 8, my lord? Order 39, Rule 1. Paragraphs A, B, and C, my lord, clauses A, B, and C are discussed, my lord, from the 5th line. Under Order 39, Rule 1B, the injunction contemplated arises from the defendant threatening or intending to, or actually removing or disposing of the defendant's property for defrauding the plaintiff. The shift in perspective is the use of the expression his under Order 39, Rule 1B in comparison to the property in dispute in the suit under Order 39, Rule 1A and C. A weightier onus is hence placed on the plaintiff to prove the circumstances warranting orders under either of those two provisions. The higher order of proof required can be explained thus: injuncting a property in dispute in a suit where both the parties would have the opportunity of determining their rights in the course of trial has less severe implications compared to.
All right.
Next line, my lord. Order of this nature are
Okay.
therefore generally passed only after proof. My lord, only one thing. May I just show the averments made in support of the prayer for attachment before judgment? My lord will find that.
All right. You have to say something. It's okay.
May I just show that pleading at paragraph 23? That is.
Because I believe Mr. Banerjee is not pressing for any relief as against my clients. I am the respondent numbers 4 to 6. Only 2 lines, Manoj. Manoj has seen we filed a suit wherein we've challenged the loan agreement. We've said that our digital signatures have been fraudulently used.
That you had said even in the earlier section 9 also.
Yes, Manoj, but subsequent to that, we have filed the suit, and the order of subsequent to that, we filed the suit. There, the Section 8 application was filed by the finance company, which was dismissed, was allowed. I'm sorry. We carried up an appeal before the Honorable Supreme Court. Malad has seen there's a stay of operation of that order. So, as on date, the agreement between my clients and the finance company, Malad, is at large. The issue as to the validity of that agreement by my clients is at large. So, Malad will kindly not grant any injunction on the basis of any condition or term contained in that agreement, number one. Number two, Malad, also on the merits of the case that they've come to court with, because in the event Malad is holding that I am still bound by the agreement, despite the pendency of the suit and the matter before the Supreme Court, Malad will kindly note page 175 once of the application. Malad, the due dates, I'll just indicate what I'm trying to say, Malad. 175 is their tabulation, their statement of accounts, on the basis of which they allege my clients also to be jointly and severally liable. Malad, we'll kindly see that the due dates in respect of every single tranche on the basis of which the debt allegedly has arisen is of July 2024, June 2024. More than 1.5 years past. There is no urgency that has been pleaded or shown before this Honorable Court for passing of any interim measure of protection as against my clients or in fact against any of the respondents. So Malad will kindly consider, Malad is today considering a prayer for ad interim injunction as to bank account and security being furnished. So 1.5 years past, no Section 9 filed prior, no Section 21 notice, no invocation or attempt to resort to arbitration. The only attempt was by way of the Section 8 application, which was Malad stayed by the Honorable Supreme. That's all. Okay.
Mr. Banerjee, tell me one thing. How are you covered by the agreement?
How am I covered by the?
Agreement. The loan
Yes,
agreement.
Malad.
Because if the principal in the earlier agreement,
Yes, Malad.
in terms of clause 3.1, 3.2,
Yes, Malad.
the money was to be paid to Vedanta. Today it is supposed to be paid to Gupta. They are the principal in this case.
Yes, Malad.
So how are you covered in that agreement?
Yes, Malad. This is the same story which they started in the last Section 9. So it is the same here. So I'll give an answer to that because it's on record. My lord, kindly sees why is that 15800, my lord, is the number, my lord, for that,
That 158
particular tranche.
15800, it is subsequently from the record, it is also shown that there are different loan numbers which are there. The payments which you had shown as outstanding of 24 lakhs, 24 lakhs, 17 lakhs and others are in terms of a different loan agreement, not different loan.
No, my lord, that's exactly what
Let
they're
them-
trying to confuse now, which they could not then, but they're trying to. Now, my lord, kindly sees.
This can't be decided without exchange of
No, it will be, my lord. It takes 2 minutes, my lord. Kindly, my lord, gives me a
Yes.
chance to reply. My lord, kindly takes, my lord, their page 83. I would only say this is very unfortunate, but kindly takes their page 83, which is part of their, my lord, affidavit in opposition, which they filed in the last Section 9.
Yes.
Loan account number is 1. Agreement is 1. Loan account number is 10481. That never changes, my lord. That never changes.
How do you answer the...
But may I just show under that statement
Just-
itself?
No, just answer this question.
Yes, my lord.
In terms of the agreement,
Yes, my lord.
which starts from page 23,
Yes.
the disbursement facility
Yes.
in terms of 3.2,
Yes, my lord.
The schedule which is there at page 29,
Yes, my lord.
the principal is Vedanta, right? The money has to go in their account in terms of this loan agreement. Show me anywhere where you have a loan agreement where the principal is Gupta.
There is no principal as Gupta, my lord. I don't have to, my lord, go into that. Why I say, my lord? Kindly comes to page 83. I'll answer all of that. There is only one loan account, my lord, which he cannot dispute. The loan account number is last is 0481. That's his opposition. He has annexed. Under the same loan account, there are different tranches. Now, my lord, I am so grateful that my learned junior friend, my lord, showed the same statement. My lord, kindly comes to that statement which he has shown, which starts at page 68. He has enclosed. My lord, that loan account is 0481. Now, my lord, he has shown, my lord, the entries. Kindly sees, my lord, 285 at page 72. This is his statement. I have not prepared this statement. He has annexed it before the section 9 quote earlier. Now, my lord, 285 is, my lord, the 282, Lordship rightly pointed out, 282 is the earlier tranche, which is 15800. And this particular tranche of 15800 is again appearing at 288, and then, my lord, at 293, and then, my lord, again at 293. Why? Lordship will get the answer, my lord. Section 9. Because, my lord, I have not annexed the annexures. I don't think this they'll dispute. Page 45 of the section 9 earlier had, my lord, the tranche, my lord, invoice. There was only one invoice, which was 15800. So, my lord, that is why the court held that 15800 amount is paid. The other amount that you have paid post the request which I showed, my lord, which he did not deny. He did not say once, my lord, that I am denying that document which I read out before, my lord, for restructuring. Was, my lord, disbursement made post the section 9 being filed? So once, my lord, that becomes a cause of action, my lord, that's a fresh cause of action. So that section 9 was not maintainable. But, my lord, to say that, my lord, they are different agreements is incorrect on the face of it. Because, my lord, there are only different tranche numbers. Kindly sees, my lord, the same page 72, the tranches which I had shown, my lord, the numbers are there at 287, 289, then, my lord, 292, and, my lord, 295. So therefore, my lord, the invoice he brings, I make the payment. So, my lord, if that be so, then he cannot blow, my lord, hot and cold together. He is not denying the Vedanta one, which is 15800 in the same statement. In the same statement.
He's saying that Vedanta. As
So,
far
my
as
lord,
Vedanta is concerned,
my lord,
he's saying-
the only issue is that he is not, my lord, denying the disbursement. That's the most important part. So money is due and payable, my lord. The prima facie case that I have to show before my lord is established under the same agreement. He is not once saying that disbursement has not taken place or money has not gone to him. He is saying, my lord, that money has gone to me. Then, my lord, if money has gone to him, his defense should have been like what he did in the earlier section 9, that I have paid back this amount also.
When was the last date when you were supposed to pay? June and July of 2024?
Yes.
You have come to the court at the end.
Because, my lord, because, my lord,
urgency, Mr.
my lord, because, my lord, the suit was filed by them and I had to file a section 8.
All right.
The judgment was passed. Kindly sees the
So
judgment
today
has
there's a
been
stay-
passed in
There's
November.
There's a stay from the Supreme Court. More reason not to.
I have, there is no stay against the respondent number 1.
That's right. It's
There's
only-
no stay.
I get it. But because you are making this argument,
Yes.
that because the suit was filed, and that is the reason we didn't.
So I'm not proceeding against respondent number 226. I am not
Could have
proceeding.
proceeded against them. What has taken you 1.5
My lord,
years?
I today come before my lord. Is there, my lord, any statement made that the amount has not been paid?
Let them file their response.
My lord, kindly, my lord, considers two things, my lord, before that. Two things. I'll rely on his own judgment, where the interim order has been passed. The surfacey judgment which he has showed, the court has passed the interim order. But I show that also, and the other judgment of Justice Bhattacharjee. Now, my lord, kindly sees, money disbursed and not paid is admitted by him.
I'm not impressed with any of the judgment which he has shown.
I know
only
that,
impressed
my lord.
with the facts of the case.
Correct, my lord. Now, my lord, kindly sees, my lord, prima facie, money disbursed from the statement, my lord, is not disputed by him. So the money is due and payable. under the same agreement.
The money is due and payable.
Under the same agreement.
July of 2024, there is no pressing urgency. Let them file their reply.
My lord, kindly, my lord, considers this, my lord, that, my lord, in the meantime, if they, my lord, operate the account, my lord, my lord, the prayer that I have asked for is, my lord, keeping that amount. I have not asked for stopping the account, my lord, from being operated.
Disputed amounts which are there.
My lord, there is no disputed amount. Kindly considers this, my lord.
First, we have to cross the threshold of whether this loan agreement
Yes.
actually covers all these payments.
It is, my lord, kindly sees the same statement.
Let them file.
But this, my lord, is, I would say, my lord, unfortunate on their part to say this,
No,
because, my lord, he's relying on the same statement.
See, the payment goes entirely into the account of Vedanta as far as the first loan is concerned, the agreement which you have put in place.
My lord, it is not, because the clause says, my lord, he is to put in the invoice. I am supposed to make him the payment. Now, my lord, kindly sees page 68. The, my lord, customer name is Bharat Electricals, which is the respondent. Account number, my lord, the loan account number is 0481. In the same statement, my lord, in the same statement, my lord, he has tranches of 15800 which has paid at page 72, and my lord, the tranche of 152738 and onwards he has not paid. So, my lord, there is no separate account, no separate loan account. There is one loan account with different tranches, and that's exactly what Justice
from your loan agreement.
Yes, my
you
lord.
would have been able to show that this is the account which is being operative and no other account operates.
He does not have any other agreement. Let him disclose, my lord, on Monday that he has any other account with me. No, my lord, not for, my lord, not for weeks, my lord. That's entirely the, my lord, idea that, my lord, I will take weeks to file a, my lord, why I say Justice, my lord, may I just complete? May I just complete? Miss Justice Bhattacharya, my lord, had passed an order which I have enclosed to this petition in the last round, asking them that you have made a payment, disclose it. That affidavit till date, my lord, they had not filed in the last round of litigation also. That's, my lord, at page, my lord, kindly takes, my lord, page 114 of this, my lord, particular application itself. But somebody should come with a defense with clean hands. I have no other agreement with him. 114. Learned counsel for the applicant submits that a proposal for settlement was given, which is denied by the learned counsel for the respondent. This is the same tactics that they have been doing. Be that as it may, a question has roped up as to whether the respondents has paid certain amounts to the applicant. In order to establish such payments, learned counsel for the respondent seeks a week's time to file an affidavit enclosing relevant documents, incorporating the necessary pleadings regarding such payments. Leave is granted. No such affidavit ever came up, my lord. Now, my lord, comes, my lord, may I just, my lord, indicate, my lord, I can understand, my lord, I was sitting, my lord, quietly when he was making his submissions, my lord. Now,
age difference.
Yes, I understand, but I don't want to use that word, my lord, exuberance. Anyway, my lord, kindly comes to page 68. Now, my lord, there is one agreement. He does not say he never, my lord, made any submissions before, my lord. He has been very particular that, my lord, there are other agreements with him. He never made that statement. He is, my lord, saying it in the air that, my lord, this is not part of the same agreement. The question falls then, my lord, is there another agreement with you? There is no other agreement. My lord, money given to him is not disputed by him. So if money given to him is not disputed, my lord, under the same statement of the same loan agreement, my lord, he is showing that money has, and my lord, for 15800, he is saying that it is reversed back, debited and credited. But for the other invoices, he's never showed it to my lord that he has made the payments. So that is due and payable. So prima facie, my lord, if I can show that it is due and payable, I am asking, my lord, for a very innocuous prayer. I am not saying that don't operate that account. If that I was, my lord, asking, it was a tall order. I am saying, my lord, keeping this amount, you operate the account. That is all I am asking. Now, my lord, kindly sees the two judgments that he has shown. Although I find, my lord, lordship is not impressed. The first judgment that he has shown of Justice Bhattacharya, my lord, paragraph 2. That's, my lord, with regard to an immovable property. I am asking for a, my lord, a prayer in respect of a movable property. Then, my lord, kindly sees the Bombay judgment. But he was reading the earlier paragraphs. Kindly comes to, my lord, paragraph 36. Paragraph 36.
That's
in fact,
a different aspect altogether.
Yes, kindly sees paragraph 36. Court passes the interim order. Kindly sees paragraph 36.
This is once you invoke the arbitration, he can rely on all these aspects.
That is different, but kindly sees, my lord, paragraph 36 and 38. the petitioner has claimed interim measures in the.
Stopped you from invoking the arbitration.
My
For
lord,
the last
today, my lord,
almost 2 years, you have
my
been
lord,
sitting over
if
things.
lordship passes the order
First round,
today,
second round, all
my lord,
you're
I am,
seeking is an injunction.
my lord, I have a
matters under
fresh cause
Section
of
9.
action under this agreement because, my lord, the last order or the judgment says so that, my lord, the section 9 which I had filed does not have the pleadings of these payments being made. So my today, if my lord passes the order, my 90 days will start from today. It won't start from that day, my
You
lord.
could have initiated the arbitration.
Well, I
proceeding,
don't
but
need to. I don't need to. Why I say, my lord? Because the earlier section 9, the amount was satisfied. That's the finding. So, my lord, I don't need to go for an arbitration as far as that tranche was
but even
concerned.
as far as this is concerned,
This, my lord, today is before my lord, I am here. Today, if lordship protects me,
1.5 years.
my lord, section 9 I did.
Money has been
My lord,
due
I am.
for 1.5
My
years.
lord, law is very clear. My lord,
If
my.
there is a breach in the agreement, you could have invoked.
My lord, I may not, my lord, in every case, we, my lord, first come to my lord with a section 9 to protect
After
ourselves.
1.5
Thereafter, we go. Thereafter, we go for my time will start from today. Now, my lord, all I'm trying to show, my lord, is that from the document, prime emphasize is that, my lord, the same document which is enclosed there at page 68.
I am not convinced.
But this is
Let
the
them
document that they are relying upon.
Let them file the reply.
But, my lord, there is no other agreement. Kindly ask them if there is one more agreement with him.
Let them file the reply.
But, my lord, if that, by that,
The section 9.
my lord, by that time,
We are not saying, we are not deciding, we are not throwing you out of the court.
No, I am not on that. If that time, my lord, if he uses the account and, my lord, takes away the entire amount, then, my lord, I would
There are
not be
means
able
and
to
ways of-
secure it.
There are means and ways of protecting you.
My lord, kindly protects to that extent that he can use the account. Use the account. I am not standing in the way of him using the account. Only he might keep this amount there and use the account. That's the prayer.
Is
But
there any admitted amount which has not been paid by you?
My lord,
What,
lordship is
do
being-
you have a separate agreement? Are you saying that you have a separate agreement?
My lord, I have to take instruction on that, but even without written agreement, an NBFC can disburse money. Lordship is aware of that.
You
My lord, they can
don't
kindly see.
don't mislead the court.
Certainly not. Not my intention to. I have shown your lordship from the account statements, and I have shown your lordship the
Your,
coordinate bench.
if your argument is to the extent that there's a separate agreement,
Yes,
then I can understand.
there are separate agreements. Yes, separate agreements need not be written agreements.
Oh.
There can be oral agreements also, and that has been noted by the.
this gives the answer, my lord.
All right.
This gives the answer, my lord.
My lord, can you see?
This gives the answer, my lord.
This
Kindly
is how
see
it
from the.
is.
My lord,
Yes.
this will amount to rewriting of the agreement between the parties.
I am not. I am relying on the same agreement.
Whether there is a separate agreement, separate transaction, I have shown your lordship the application numbers are different. Let me put my case on affidavit.
That is the tranche number.
I'm allowing you to file an affidavit. All right.
My lord, no
Thank you.
security
Kindly
is granted
protects
at
to
this
that
stage, my
extent.
lord. My
Now it
business
has
will
come
to
out that
court.
there is no other agreement. So he'll take away the entire money.
Section 9 of the Contract Act says agreement can be written or oral.
But there is no oral agreement which an NBFC which happens, my lord, for such sums of money. We all know, my lord. Let us not create a new case here.
Restructuring, my lord, is there any restructure after restructuring, which is an admitted position? Is there any new sanction letter?
My lord, I have
not.
given the amount under the
There is
same
not.
agreement.
My lord has
There is
seen the
no
schedule
question
of
of
the agreement has not
restructuring
been
here, my lord.
amended.
Both of you can't speak at the same time.
My lord, I have remained silent for a long time. Your lordship has expressed that lordship is not prima facie satisfied. Question has been put.
Well,
to me
I don't
as
think
to whether
lordship
there
has
is any
expressed
further
it in
agreement.
that way.
I'm not expressing anything. My order will express what I
My
want to
lord,
say.
there is.
Grateful.
Well, lord, kindly hear me for one minute. My lord.
Yes.
Jani,
Without a
Jani,
written
it's the
agreement.
same
Your
loan
lordship
number.
see from the
I'm
black and
putting
white.
questions.
Very well,
Yes.
my lord. I'm addressing the question. There is, my lord, whether is there any other written agreement? Take instruction.
not aware. We have to take instruction.
Yes,
but
well, we have
since
to
it
take.
was a rescheduling agreement,
Kindly
there is
don't
no
do things.
agreement on.
After the admitted restructuring, there is no fresh sanction letter issued. There is no amendment to Schedule 2, which names Vedanta as the only principal. My lord, it is stated that I have to indemnify the principal also. There is an obligation under that. So, my lord, if today third-party invoices are paid, I have no obligation to indemnify that principal under this agreement also. That will also amount to rewriting of that clause in the agreement, which says I have to indemnify the principal. Next, my lord, if they have made disbursements to me directly, which is also not the contemplation of this agreement, any transaction that is the purported cause of action in this petition can have no nexus with the loan agreement placed before your lordship. Next aspect, my lord, is that if they have made disbursements otherwise, deholds a written loan agreement, their remedy is by filing a suit. They cannot invoke arbitration and, my lord, seek interim relief in aid of that arbitration. My submission is only this, It bears no nexus to this loan agreement, my lord. It is not arbitrable under this loan agreement.
Under the same statement, my lord, he is, my lord, accepting one, my lord, transaction. Under the same statement, he is saying, my lord, I am going to accept the other transaction. That's, my lord, unusual.
Issues that have to be decided by the arbitrator. There is no appeal from that finding.
I don't need to make an appeal from that finding, my lord. I have accepted it.
Whether those new disbursements are under this loan agreement or not, whether they have been repaid or not. Kindly see, my lord, statement of account also has not been disclosed. Whether they have been repaid,
Are
to
you
what
saying
extent they have been repaid.
that this is not in terms of this loan agreement?
Yes, certainly I am saying that, my lord.
So then there is another loan agreement with
Yes,
me.
there is another loan agreement. which
Disclose
need
it
not
by
be in
Monday.
writing. If it is, yes, I will disclose it by Monday. No
Yes,
difficulty.
if there is
I am
another
not
loan
there-
agreement,
I am not there on Monday, Tuesday, Wednesday, my lord. We'll keep it immediately after the vacation.
by that time the amount goes. Then till that time, let them not, my lord,
My
keep
lord,
transact the account.
They have stayed still since June 2024.
That can't be his answer, my lord, to it.
Nothing will go, Mr. Banerjee. If you want that, or you want a reply from their side, we'll have it in the first week of January.
Please do, my lord.
But till that time, at least, they should not transact the account without keeping this amount. They can transact the account.
I'm not doing anything right now.
Very well, my lord. May I ask for one prayer, my lord?
Yes.
My lord, in that account, my lord, in that account, let them file their affidavit, keeps it on the reopening day, my lord. My lord, let them file the statement of that account. That, my lord, I don't think can be a hindrance on their part. With the new agreement, what we have with him, he's saying,
To file, let them file.
yes. My lord, and the bank statement of these two accounts may be given. So, my lord, I can understand whether after after today's hearing, whether he's taking out money.
We will know that.
But let that be disclosed.
Why should
I
it
am
be
not
disclosed
asking
at
for,
this stage? Why at this stage?
my lord, because, my lord, his
At all?
affidavit will come,
We'll see
and
that.
his affidavit will come. It
Let-
will not
let the-
disclose.
let
Then,
the
my lord,
affi-
he'll say, my lord, there was no order, so I've transacted.
Let the order come.
But that would be a difficulty, my lord. I am not, my lord, today, my lord, I am, my lord, out of pocket of 2 crores and more. He is not, my lord, disclosing any accounts.
More than 2 crores back.
My lord, that was in the last tranche.
1.5 years, Mr. Banerjee, you have been out of
My lord,
pocket.
1.5 years is what is striking, my lord.
Absolutely.
Lordship, my lord, is keeping it on the reopening.
Absolutely.
My lord, at least ask him to file the statement of these two accounts. So Lordship knows. No, it's not a question of examination. It will show that his my lord, intent, my lord, that he has taken out money or not. If he can show, my lord, if he can show there is another agreement, if he can show there is another,
Banerjee, we are not at the stage of execution.
I am not asking for that. I am not.
The stage
My
of
prayer would be the same.
This is section 9.
My lord, I will pray for the same prayer
We
on
will
the
see
on the reopening day. All that, my lord, all that I am asking for, my lord, all that I am asking for, my lord, is that on the reopening day, Lordship keeps it, he files an affidavit. I have no issues. If he is not able to show an agreement, another agreement with me, I have a right under prayer, but if that by that time,
To argue that time, we'll
no,
see.
if by that time, my lord, he takes away the entire money, I can't
Mr.
seek for an
Banerjee,
attachment.
If you
my lord.
have sat for 1.5 years, you can sit for 10 days too.
My lord, I
Sorry.
am agreeable.
Your conduct doesn't inspire that kind of confidence.
I am agreeable, my lord. I am agreeable.
You were losing out the money in June of 24.
I
and
am
you have come
agreeable.
to this court.
I am agreeable.
Don't make the submissions. You know, you can easily wait for 10 more days.
I am
If he
waiting.
has not transacted for the last 1.5 years, there is no apprehension on my mind that he will transact.
Very
No
well.
apprehension in my mind.
If that falls from my lord, that there is no
No
apprehension
apprehension in my mind.
that he will not transact those
If
two
he had
accounts,
to
my lord,
do it, he
accept
would
it.
have done it long back.
My lord, that is why I am saying, my lord, kindly, my lord, calls for the statement.
And this litigation has been going on in different pretext. You know, there was an earlier section 9 also.
Yes, my lord.
Again, a section 9 has been filed.
Because that has
If he
been, my
had
lord,
to
paid.
transact, he would have transacted.
My lord, if that is so, my lord, I am only saying this, my lord, if he has transacted, he has. But from today, when my lord is passing the order, let that be put on record. I am not asking for any injunction, my lord.
The present petition has been preferred
Kindly, my lord, considers that.
by the petitioner under section 9 of the Arbitration and Conciliation Act
Seeking
1996, a direction upon the respondent to furnish adequate security
Section 9
for the alleged outstanding dues payable
immediately file
to the petitioner. Full stop. In the alternative, comma, it is prayed that, comma, in the event of the respondent's failure to furnish such security, comma, this court restrains the respondent from operating their bank account specified in Annexure H so as to secure an amount of rupees 2 crores 93 lakhs 7,298. It is the case of the petitioner that a loan facility of rupees 2 crores was extended to the respondent pursuant to a facility agreement and sanction letter dated 25/7/2023, in relation to the loan account number this is the loan account number is
My lord, that is 1840, my lord, as I said. 48, the last four digits.
481 are the last four digits, my lord. Full number.
UGDADEL 000000. 6 zeros, 481.
481, my lord.
481, full stop. The respondent executed a demand promissory note and a letter of continuity, under which they alleged to undertook an unconditional obligation to repay the sanctioned facility, full stop. The respondent number 1 was engaged in retail trade with various suppliers, including Vedanta Limited and Gupta, what is it?
Gupta Power, my lord, and Gupta Power Technologies Private Limited.
This is page
103 is the invoice from Gupta Power Technologies Private Limited.
10.
103 is the invoice from Gupta Power Technologies Private Limited.
Gupta Power Technologies Private Limited, full stop. As per the sanction letter and facility agreement, the credit facility was structured against invoices raised by these suppliers, full stop. These suppliers and each disbursement made by the petitioner was treated as payment towards the supply of goods / services rendered by the suppliers. Is Gupta also made a party here?
No, my lord. They don't have, my lord,
The
agreement.
suppliers, full stop. Each tranche of the facility was to be released against a corresponding invoice, full stop. The facility was sanctioned as a short-term working capital loan for a tenure of 1 year, with each disbursement tranche having a repayment cycle of 90 days, full stop. The respondent were obliged to repay each tranche on the 91st day, and any failure to do so constituted an event of default, thereby entitling the petitioner to recall the loan and demand immediate payment of the principal along with the accrued interest, full stop. In accordance with the above terms, invoices were raised by the respondent number 1, the petitioner repaid. The petitioner disbursed the corresponding loan amounts, full stop. The respondent, it is a case of the petitioner that the respondent allegedly defaulted in repayment of the invoices dated. There are 4 invoices, right?
5, my lord. 5 invoices, my lord, post the earlier section 9.
My lord, paragraph 15 of the petition they are mentioned.
5 invoices, my lord. My lord, the 5 invoices I have enclosed also. They are, my lord, at page
103.
একটা আলাদা করে লাগিয়ে দিই। 175, my lord, I have enclosed the invoices separately. Lordship can get it from there.
Yes.
175, annexure G. Where loan account number, my lord,
5 invoices
same and the invoice numbers change.
as mentioned in statement of accounts. इसको tick to tick low page 175. 175. ठीक है? ये पूरा उसको यहाँ डालो. In it is the case of the petitioner that he had earlier also instituted a Section 9 petition, APCOM 39 of 2023, before this court for securing an amount of rupees.
May I just interrupt one thing, my lord?
Yes.
It is also my case as I read out, my lord, B, C, and D at page 23. That's what is disputing now, that I am supposed to pay to him. My lord, kindly sees, my lord, C. The lender will provide the facility to the borrower. So that's my case, specific case, that I am supposed to pay to him. He is the borrower, my lord. He's not the principal. Which is now disputing that it has gone to his account.
Yes, so this is being disputed.
This is my case, my lord.
This is your case.
Yes. That I am supposed to pay him only.
The उससे पहले एक line लिखो. Learned counsel for the petitioner states that in terms of the facility agreement, the payment was supposed to be made to the borrower, but you're not saying that the payment is not supposed to be made to the principal.
No. I cannot,
Saying
my lord.
the-
That is what is he saying, that it should go to him.
But the principal is actually receiving the payment.
Yes, through him. Through him, my lord. I am supposed to give it to him because he is giving me the invoices as I showed that document, my lord.
Was supposed to be made to the borrower. Full stop. उसके बाद करना, the petitioner submits that he had earlier filed APCOM 39 of 2023 before this court under Section 9, seeking security to the tune of rupees
2 crores. 2 crores.
2 crores. 2 crores 8,19,871. During the pendency of the petition, the respondent had approached the petitioner for settlement. During the pendency of the petition, it has been noted in the order of 12th November 2024 in APCOM 39 of 2023 that the said amount was paid by the respondent, and thus the interim relief was not granted. Full stop. This was challenged.
No.
This was
challenge, my lord. I accepted it, my lord.
accepted.
This is a separate tranche, so cause of action is.
However, it is recorded that pursuant to the alleged restructuring, fresh invoices were raised, and against these invoices, the petitioner had disbursed an amount of rupees 1,99,44,000. Right?
Yes, my lord.
That's what
Total to koto. Yes, my lord. That's the amount, my lord. That's correct.
on various dates. Full stop. According to the petitioner.
Yes, principal is 1 crore
newly
99.
newly disbursed tranches remain unpaid, and thus there's a total outstanding of rupees 2 crores 8,19,871 as on date.
Yes, with interest.
The learned counsel for the petitioner states that the facility agreement still subsists and that the disbursements were advanced in pursuance of the restructuring of the original contractual agreement. Full stop. It is further submitted that the respondent had instituted
224, my lord, not respondent number 1, my lord. Only 224 had instituted.
2 to 4 had
2 to 6,
instituted
4 to 6.
4 to 6 had
4 to 6.
instituted CSCOM number 55 of 2025 alleging inter alia that the petitioner had fraudulently procured the respondent's digital signatures on the loan documents. Full stop.
Not the petitioner is not for respondent number 3 has.
The respondent number 3
Respondent numbers 4 to 6 have filed the suit. I
Yes.
appear for respondent numbers 4 to 6 in this suit. I say that the fraud is illegally using my digital.
Who has
signature.
done the
Respondent
fraud?
number
That is-
3, not us.
No, respondent number 3 also in
Get it.
confusion.
The
No, that's not there in the plaint, my lord. New case
Respondent-
cannot be made out.
respondent,
Not there in that matter.
respondent number 4,
Respondent number 4 to 6.
respondent number 4 to 6 states that his signatures have been fraudulently used.
My lord.
Not
Forget
yeah.
about, we're not getting into it. Has been fraudulently used. Full stop. Full stop. The said suit was disposed of by order dated. What is the date of this?
Well, the suit was dismissed on 11th of September
2025.
11th of
2025.
September 2025. Full stop. SLP has been preferred. With that order,
Yes.
अभी रुक जाओ.
My lord, that's dated, my lord, 12th of December 2025.
SLP number
SLP number, my lord. 35.
SLP number
407.
35407 of 2025 had been preferred against CS Com 55 of 2025. Full stop. The Honorable Supreme Court, while its order dated 12/12/2025, had stayed the operation of the impugned judgment. Full stop. Anything else which you want
No,
to say?
this is their statement, my lord. I'm not asking for any reliefs against them, my lord.
All right.
Present
Learned
moment.
counsel for the respondent. Learned counsel for the respondent has vehemently opposed the petition and states that the loan agreement, the facility agreement entered between the parties does not cover the present tranche of disbursements. Full stop. He has relied upon clause 3.2 to enumerate his submission, wherein he states that in accordance with Schedule 2, the principal was supposed to make the payment, and in terms of the loan agreement, the principal is Vedanta and not Gupta Power Private Limited.
Gupta Power Technology.
Gupta Power Technology. Full stop. He states that the present dispute is not covered by the loan facility agreement relied on by the petitioner. Full stop. He seeks and is granted 2 weeks' time to file his affidavit in opposition. Reply to the same, if any, within 1 week. List after 4 weeks.
And may there be a date given, my lord, to
Yeah.
come back, my lord,
Yes.
so that, my lord, I can.
Shall we keep it on 21st January?
Yes, my lord. Only thing is that, my lord,
21st month,
there is
I
one
made
more
some-
submission he made. This is in terms of a separate agreement, because I have made that
Learned
specific,
counsel
my
for
lord.
the respondent states that I have already recorded that.
No, he says that not under this transaction, but my lord, I have made that prayer. If there is an agreement, let him disclose it. That's my prayer, my lord.
He said argument advanced by the learned counsel for the respondent is refuted by the petitioner, who states that the entire transaction arises out of the same loan agreement, and that
As we don't have any other
That
agreement with
there
him.
is no separate loan agreement between the parties. Full stop. But let learned counsel for the respondent seeks and is granted 2 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week. List on 21st of.
My lord, 20th to 23rd. I'm in some personal difficulty, my lord.
When do you want?
20th, I have a wedding to attend, my lord. On or after the 26th, my lord. Any
You can have it prior to that.
27th.
Or can we have it prior to that, my lord?
Second week, my lord.
Because,
up
my
to your
lord, he is
lordship's
getting 2 weeks would be
So,
over by the reopening.
Can we do it on 19th?
Yes.
Lord-
19th.
Lordship.
19th?
Lordship.
All right, 19th.
Grateful.
Extremely grateful.
My lord has directed all the respondents to file.
All the respondents. Respondent number, I'll record it.
Six, I appear.
Learned counsel, the respondent number 4 to 6 also makes the similar pair. Let affidavit in opposition be filed by respondent number 4 to 6 within 2 weeks. Reply to the same within 1 week thereafter.
Grateful.
Sir, may I have one leave to file my Vakalatnama? It's arrived from Delhi. My lord, respondent number 4.
You have to record your.
Oh, we'll stamp on
application.
that file. Stamp on.
Ready? Nakina.
Call out that matter which
My lord, I think
My lord,
his
my undertaking.
undertaking has to be
Filed
recorded.
in the course of the day.
yes, learned counsel for the respondent number 1, right?
Yes,
My lord,
1, 2, 3.
all the respondents, we are also filing
One,
during
two.
the court.
My lord, I am 1, 2, 3.
I am
One,
4
and
to
they
6.
make the
Respondent
same.
number 1 to 3 as well as respondent number counsel for the respondent number 4 to 6 undertakes to file the Vakalatnama during the course of the day.
Extremely grateful.
Grateful.
Supplementary for item number 1 and 2.
This is a matter, my lord.
Yes. They're saying it's barred by that section 14.
Yes, that is one argument. So far, there are two applications. One application is not really relevant, item 1, because there is no interim order in that matter. What is relevant, my lord, is item number 2, is his execution application. And then, my lord, I have 2 points, my lord. One is the bar under section 14 of the IBC,
Yes.
as also the interim order which he is enjoying today is in respect of a property which is situated outside the original site jurisdiction of this honorable court. Therefore, in my respectful submission, this court cannot pass any order in respect of such an asset or property. He had got the order at an ad interim stage of sorts. Now I filed an opposition, and the learned single judge has been hearing the matter, where I prayed for a modification of this order. Because the order, my lord, is a blanket order. The order of 18th November, it's a blanket order on all my movable and immovable properties. That, in my respectful submission, my lord, such a blanket order cannot be passed. Order in execution can be passed only so far as the
Mr.
assets.
Medora, that's
Hello.
why we asked you that can we
Hello.
pass this order or you said it's an innocuous order, you can pass it, you can extend the interim.
So far as the interim order is concerned today, my lord, because the matter has been substantially heard by the learned single judge. My lord, I'm told, my lord, that the learned judge will be back on Monday. Lordship can extend it till Monday, no difficulty. I will not stand in the way.
The interim order extended earlier, the interim order passed earlier is extended for a period of 1 week.
My lord, till Monday?
Monday is what?
Monday.
My humble submission is if it could be extended at least for 4 weeks.
No.
No,
I am opposing that.
19 till 23rd. Let this matter be listed before the roster bench on 22nd.
Grateful.
My humble submission is I have got an award.
Sir, this is not my roster. Since the judge is on leave, it is before me. I'm extending it since the interim order is expiring today. I'm keeping it before the roster bench on the 22nd
23rd.
to do the needful, and I've extended till the 23rd. All right.
Most grateful.
I'm grateful, my lord.
Item number 4.
This is my section 9 application, my lord. My lord, I was last question. My lord would recall that I was praying for attachment of the bank account. My lord, today I'll only
Ask for it, sir. Your prayer doesn't ask for attachment of the bank account.
my lord in section 9.
Verbal prayer.
But we do you respect, my lord, in section 9, even if there is not there is no prayer, my lord,
On behalf of the
the
respondent,
the court can mold the
Lordship,
prayers, my lord.
the
And in
Vakalatnama is
that
being
regard,
filed.
yes.
The Vakalatnama of the on behalf of the respondent is being filed and it is in progress. In the meantime, Lordship, the settlement is scheduled,
Yes, me too.
and this is a letter of
When is
settlement.
scheduled?
Yes, my lord. My lord,
Lordship,
we have got it today. We'll take instruction on this, my lord.
to be precise, the actual loan amount was
Because
about
it's not
25
signed
lakhs.
also. My lord will check that it's not signed also.
It is about 25 lakhs, and the settlement amount is
I will
9
not
lakhs.
pass any order. Let
Yes,
it
ma'am.
be.
Let it
Lordship,
be
this is the acknowledgement. They have received 6.5 lakhs already. This is a
kindly records it, my lord, and keeps it in the next month.
the remaining balance will be cleared by the end of this month.
Can you record such submission, my lord, and keeps it next month?
Take down. The petitioner has preferred the present application under section 9 of the Arbitration and Conciliation Act, seeking a direction upon the respondent to furnish an adequate security for the alleged outstanding dues payable to the petitioner. Full stop. It is the case of the petitioner that a credit facility of rupee 2514193 was extended to the respondent pursuant to a loan agreement dated 28 September 2023, repayable in 48 months along with interest. Full stop. It is a case of the petitioner that the respondent allegedly defaulted from the 20th installment onwards. Full stop. Consequently, the petitioner, by letter dated 17/7/2025, demanded the outstanding dues. Full stop. As the respondent failed to make the payment, the petitioner referred the dispute to the online dispute resolution platform, where an arbitrator was appointed. Full stop. The same was objected by the respondent, leading to the arbitrator recusing himself from the said proceeding. Full stop. The petitioner states that steps are being taken to appoint a fresh arbitrator. Learned counsel for the respondent appears and states that settlement talks are underway. Full stop. He states that an amount of rupees 6 lakhs, right?
The amount of settlement is 9 lakhs
How much have
77,000.
you paid already?
About 6 lakhs.
He states that approximately 6 lakhs have been paid, and that in all likelihood the amount will be settled
By the end of this month.
By the end of this month. He seeks 2 weeks time to file his reply.
Lordship, the acknowledgement is also there. I've provided.
Reply. Affidavit in opposition. Reply, if any, within 1 week. List after, in 4 weeks, I think it will be settled.
4 weeks.
4 weeks. Lord.
After 4 weeks. Give a date.
Deeply read.
Next.
Item number 5.
Item number 5, similar, my lord, application, my lord. My lord, I'll pay only for prayer A. A so-called be issued to them by the amount default. Should not be paid as security, my lord.
Prayer?
Prayer A, my lord.
The petitioner has referred the present application under section 9 of the Arbitration and Conciliation Act, seeking a direction upon the respondent to furnish adequate security for the alleged outstanding dues payable to the petitioner. It is the case of the petitioner that a credit facility of rupees
25 lakhs. My lord, annual.
252513,803 was extended to the respondent pursuant to a loan agreement dated 29/11/2023, repayable within 36 months along with interest. Full stop. It is a case of the petitioner that the respondent allegedly defaulted from the 19th installment onwards. Full stop. Consequently, the petitioner had issued a letter dated 14/8/2025 demanding the outstanding dues. Full stop. It is further stated that the matter was referred to an online dispute resolution platform wherein an arbitrator was appointed. Full stop. Since the respondent objected to the said appointment, the arbitrator recused himself from the said proceedings. Full stop. The the respondent is directed to file his affidavit in opposition within 2 weeks, reply to the same within 1 week thereafter, list after 4 weeks.
Much obliged. My lord. 4 weeks.
Item number 6.
Yes, I am for the respondent. Now we have sent the Vakalatnama to get it signed. It's on the way, Miller. And
What about the payment, sir?
Lordship, there is we need to get the informations of these payments also as well, because no documents has been annexed. But as per 19 lakhs was
is there.
19 lakhs was the loan amount, 15 lakhs is due.
इसको लिखो सेम होगा अमाउंट चेंज करो 19,08,457
Show cause.
लोन अग्रीमेंट डेट चेंज करो 15/2/23
है नाम तो दिया
और लेटर का डेट होगा 15/10/20
नहीं
ठीक है बाकी सब चीज सेम होगा एंड यू फाइल योर रिप्लाई
Yes, Mr.
Granted copy for the respondent seeks and is granted 2 weeks time to file his affidavit in opposition.
Now the
Reply to the same if any within 1 week, 4 weeks.
Great.
equal to comparison.
Item number 7.
My lord, service is complete, my lord. A similar order may be passed, my lord. No.
Changes if it's amount 17,20,372. Loan agreement 18/10/2023. Letter 17/12/2024. Respondent directed to file affidavit in opposition.
That's true.
Reply within 1 week. Same.
Mail report kori deto. But similar matter, my lord, I don't want to praise for any orders, but they are talks of settlement are going on, my lord. They have sent email dated other side, email dated 18th December. So kindly keeps it in the monthly list, my lord.
Learned counsel for the
Item number 8.
8.
learned counsel for the
Affidavit service time, you know.
settlement talks are underway. We request for a short adjournment. Let this matter be listed
Service.
in the monthly list of
Monthly list of January, man.
January or February.
Jan.
Monthly list of January.
It is similar order. Well, similar order as 7. Is 8. This is 9. Similar order as 6, my lord.
Whereas 6. This is item 9, right?
Yes, item 9, my lord.
Credit facility of 15 lakhs. Then I could.
12 lakhs pending.
How much is the credit facility?
Ma'am,
Amount?
credit. Just credit facility of 15 lakhs, my lord.
Loan agreement date?
Loan agreement date 27th November 2023.
27 November 2023. Recall notice?
Recall notice, my lord. 25th March 2025.
Respondent directed to
Last. Solicitor কি করবো?
Item number 10.
Similar order, my lord, and the service term. My lord, credit facility of 18,50,000, my lord.
18,50,000. Agreement date
Yes, agreement date, my lord.
30th June
30th June, yes, my lord. 30th June 2023.
and the recall notice
Recall 21st March 2025, my lord.
21st March 2020. 4 weeks.
Maharaj,
Item number 11.
my lord, similar orders we passed. Service, sir.
How many? Last. Amount?
So, yes, ma'am.
Amount.
Amount. My lord, amount is 30,32,827. 827, my lord.
827. 30 lakhs, 32,000.
My lord, agreement dated 22nd July 2023.
22nd July 2023.
And the termination notice is 16 June 2025. Much obliged.
Communicate the order and file a
Affidavit of service, yes.
this order shall be copy of this order shall be
Communicate with our
communicated to the
We'll do that,
Learning
ma'am.
Council for the respondent. Affidavit of service shall be filed on the next.
We'll do the service. Much obliged.
Item number 12 and 13.
My lord, that enforcement of foreign award, and there's order which has been passed that the execution will appear along with the matter. It is appearing, it appears, my lord, the execution is it's in the non-commercial division. So, my lord, I am willing to proceed if there's an order of the court and it's appearing here.
Somebody has to take steps to bring it on the commercial side.
If your lordship has, may not, whatever your lordship, we can, I mean, if the department.
Your lordship, my lord. It was taken up by your lordship possibly on last Monday, my lord. I am not very certain if I remember.
Yes,
I pointed out that, my lord, the affidavit in reply was not served.
Oh, sorry.
No, I don't think it has not been served. It was served, my lord. The hard copy was served yesterday evening or yesterday. And, my lord, a soft copy, of course, was given, my lord, day before yesterday in the night. Now, my lord, it appears, my lord, a rejoinder is required. I will indicate to your lordship why. Now, my lord, there.
But you had indicated a survey joinder is required.
Maybe. I said that it may be required.
My lord, may I say something?
I had recorded.
My lord, this is a reply to their opposition, which was not there. We have discovered.
Last order টা কোথায়? আরে সোমবার না মঙ্গলবারের যে অর্ডারটা
Not in this matter.
My lord, in the section 9, there were 2 affidavits filed.
Yes.
Sorry. In the execution, there were 2 affidavits were filed, opposition and a supplementary opposition. So, my lord, on the last occasion, we gave you the affidavit in reply to the supplementary opposition. To the main opposition, which was earlier, it was not there in the file. And, my lord, we checked, my lord, it has been affirmed around about the same time as the supplementary reply, which was taken on record. But apparently it was not served. It's there. So we served a copy. And if your lordship permits me to file this reply.
This is the
reply to the main opposition. My lord, if your lordship permits, my lord, this is the
reply to the but this file in the right this commercial division, right?
Yes,
No.
It was from the very beginning in the commercial division.
No.
See that regular cost title to that.
You see, no. The execution application is non-commercial division, my lord, which is appearing today.
Now, my lord, in that event, my lord, I will take the point that they have served me a wrong.
My lord,
It is written commercial.
in the EC, it's written commercial. Oh, it's been huh? What's that? No, it is not written. It is not written as EC com. It is written at EC, but
at the bottom it is written.
it's a commercial division.
So only numbering possibly is required.
So this is commercial division then. My lord, I am extremely sorry. In the previously, I believe, my lord, when you filed it in the commercial division, that EC com system had not come. So which was filed at EC, but written as commercial division. So it's okay, my lord. What I've been laboring on, it's okay, my lord. My lord, both can be
It
heard.
should be fine. I guess earlier the com was not there. Now I think
It's regularization.
no, it doesn't even require that.
No.
If it is already there, you know what he's saying.
My lord, even if
What I can understand from what he's
even if the department is required to, my lord, put a different number, my lord, that's a different question altogether. I have no difficulty.
right. No, but I think it is
Sir, I'm
not
sorry.
even, it is not
I
even
myself
required
didn't-
because earlier probably it was EC.
Only EC, possibly.
Only
yes.
EC. So
Let it remain, my lord. There is no difficulty.
then there's no problem with that.
নাম্বারটা ইসি কম হওয়ার কথা সেটা ইসি কম নেই
So affidavit
My lord, there is no scope for, I mean, a reply to a reply. My lord, otherwise, it's a fight, my lord, battle of forms.
I'll
Like,
tell
my
you,
lord,
lordship, why. I'll tell you, lordship, why I am indicating. Now, my lord, we have taken a specific point that, my lord, the application has been made on the basis that, my lord, properties are within jurisdiction or, my lord, in the state of West Bengal. In the affidavit in opposition which we have filed, we have said that, my lord, the properties are not here, but all these properties are in Odisha. Now, they have denied in the affidavit in reply. Now, I want to, my lord, bring on record the documents which are there, my lord, to show that these properties,
my lord,
properties are, my lord, at Odisha. All the original, I mean,
in Bengal.
my lord,
in Odisha.
my lord, may I reply to that small thing, my lord? My lord,
No, the execution has been filed only because the properties were supposed to
That
be
is,
in,
yes, that is the ground.
that
yes,
is the ground.
Yes.
when I,
They have spoken about my office, my lord. That office, my lord, is a rented office. I have stated that. They have in the affidavit in reply also given a new bank details of a new bank account which I am required to deal with.
Yes.
may I answer? My
Yes,
lord?
Mr.
Yes. Firstly, my lord, the office he talks about, my lord, is the office which was mentioned in the agreement, arbitration agreement, and the agreement itself. So I have included carrying on business is one aspect of attracting jurisdiction where the defendant is, and the other is location of assets. Now, my lord, if he's carrying on business, part of the assets definitely arises here. And my lord, if there
Not
is
really.
my lord,
If he's only carrying on the business.
if he's carrying on business at an office, that office,
But
the fixtures, the movables, etc., are always located. That's one aspect. And the law, as far as I know, my lord, if you are carrying on business, which is the main, which is over there, my lord, there is a judgment to the effect under Order 41, Rule 27. You come as a judgment debtor and say there is no property over you. So, my lord, there is a judgment I will show you that he has to first come. That is the order in execution. But more than that, my lord, my first, because this will go on execution. So I filed a section 9.
Yes.
When section 9, my lord, I have only mentioned that there is a similar order by another party against this person. When, my lord, an order for security was given by Justice Kapoor, went up in division, sustained, went up to Supreme Court, it has been given. So why not in my case? That is the short point.
Immediately after the vacation, my
That
lord,
is okay.
by
But
5th or 6th, I shall come up with this rejoinder by.
But no, my lord.
But kindly record, my lord, that I.
Let him file a rejoinder.
Yes, sir, and
Bring the documents and, my lord, I shall state that the bank account is not, or the The position of the bank account.
इसमें लिखना this execution petition is item number.
My lord,
Execution টা কত?
my lord, your lordship will hear this section 9 because what will happen, my lord, this
I'm just recording it that you are filing your reply.
sorry.
That is item number 13.
Just taking it on record. So item number 13. Item number 13 में लिखो. The reply filed by the respondent. You are respondent in that.
My lord.
You are the respondent
No,
in the
no, I am the petitioner in both. I filed the execution first because, my lord, it will take first to be recognized in by you. My lord, I filed the section.
reply
9.
filed by the petitioner is taken on record.
এই পুরনি মধ্যে
As far as Sir rejoinder, you are filing the Sir rejoinder is the section 9, Mr. Mitro.
No, no, my lord.
Sir rejoinder, you want to file it
in the EC.
in the EC itself. All right.
But the section 9 is ready also for hearing. I will proceed with the section 9.
And counsel for the respondent states that he wishes to file a Sir rejoinder to the reply filed by the petitioner. The grounds on which he states that the Sir rejoinder is necessary is that the
আর কিচ্ছু বলবে না
Fine.
শুধু ডকুমেন্ট
Has
গুলো অ্যানেক্স করবে আর ব্যাংক
indicated
অ্যাকাউন্টের আর নাথিং ফার্দার
that the reply has indicated some new facts to which an answer is relevant. On this ground, learned counsel for the respondent seeks to file a Sir rejoinder. He is granted 2 weeks' time to file his.
My lord, your lordship is granting time. All these points have been taken in his opposition.
1 week time after vacation.
My lord, then I will proceed with my section 9 at least. This can wait. I mean, it will.
He'll file it in 1 week. We are giving 1
My
week.
lord, if your lordship gives 1 week, I don't know what will come. I mean, then your lordship directs him, he is within jurisdiction to disclose his bank statement, which I am not supposed to know.
Within a period of 1 week. He seeks and is granted.
This is what I want.
Ready to file it within 1 week. List the matter, both the matters on. जिस दिन थोड़ा खाली हो. You see the. But this will take time.
It will
Some time, my lord, but if your lordship is again granting, my lord, it's like, my lord, offer, acceptance, battle of forms, they say, my lord. Now, my lord, I don't know, my lord. Your lordship is permitting.
So most people should feel satisfied. that I have done everything.
My lord,
It's just
my
that it should not be a
client is
ground
not
to
faced.
delay.
My
That
lord,
shouldn't be. But
already,
when
my lord, a section.
Mr. Mitro is
I can
here,
tell
he's
this
making
much.
submission, then I'll take him on face value that he does not wish to delay anything.
if the affidavit in reply was
20th January.
My lord, 20th January, and the time
No,
to fight.
advantage of having seniors like both of you is that we take you on face value. So if a submission is being made, I'm sure it is being made with some sense of responsibility. I don't think so. It is only to delay.
no
My lord, your lordship is seeing our face in front, and in back is our client's face.
You have done your job. You have opposed it.
At key electronic. My lord, it's
20th.
21st. My lord, can it be?
All right, 21st.
Well,
It's a Wednesday.
my lord, when is the time? My lord, by which time? My lord,
Let's not indicate a time.
my lord, last my lord, again. At least fix a time, my lord, for 2
You
weeks.
fix it. No. Oh, 1 week.
Oh, 1 week.
1
week after.
Oh, no, that not that time. My lord, I will not ask for. So 1 week. He
1 week
wanted
after vacation.
yes
1 week.
absolutely
Make it 2 weeks only.
My lord, 1 week after vacation, in case I will.
I'm giving 2 weeks, so it will be 1 week after vacation.
Yes,
1 week
yes,
is
of course.
2 weeks time.
2 weeks time. Okay, if I am not asking for any time to file reply because it goes for affirmation in Bombay, again
It will never come.
will come.
ballot.
Yes.
Can it be 20?
20 was fine. 21st, I have a matter in Delhi, my lord.
22nd, I keep my execution matters.
No, my lord. No.
Don't keep a Friday.
23rd chutti, it's holiday.
My lord, then 19th January. Just because you heard that it's
27th
not
of
able.
27th of January. 27th of January.
My lord, you please keep it on 20th. He says he'll be online. Now this way, my lord, because
20th of 20th. 20th is fine.
yes.
Call this fast.
But both matters to appear there.
Both the
I
matters.
was sorry that I said the execution is not filed in the commercial. Actually, it was.
It was.
I missed.
It's all right. Because probably you were looking for the EC com.
Yes,
So,
yes. My lord, will your lordship direct the department if they want to name it com?
it is noted that the department is directed to grant a new number to the EC so and so.
My lord, grateful to you.
उसमें एक लाइन सुनो उसमें ऐसे कर लेना since it is noted that the present petition has the number EC 57 or whatever it is, full stop. The department is directed to take necessary steps to take necessary steps. Who's there? How many of them are there?
ECCOM 14 of 20.
14 of 2025, my lord. 14 of 25, my lord. My lord, wait for the judgment letter, my lord. My lord, there are 3 persons, my lord.
Anubrata Kole. You are there. पैसे क्यों नहीं दे रहे हैं?
नहीं सर पैसा दीते पारबो ना सर
देना पड़ेगा वरना फिर जेल जाना पड़ेगा क्या चाहते हैं
স্যার গাড়িটা ওরা নিয়ে নিয়েছে কোম্পানি নিয়ে নিয়েছে স্যার এরপরে পয়সা দিতে পারছি না বলে নিয়ে নিয়েছে এরপরে স্যার দিতে পারবো না ওই টাকাটা
जितना भी पैसा बचा है वो तो दोगे
স্যার নেই কিছু স্যার
तो नहीं दोगे तो फिर जेल भेज देता हूँ कुछ दिन के लिए
My lord, may it be recorded that স্যার দেখুন এবার
देना पड़ेगा
কত টাকা স্যার দিতে হবে বলবেন
वो वकील साहब बात करेंगे गिव अ ओथ
বলুন আমি শপথপূর্বক বলছি
আমি শপথপূর্বক বলছি
এই মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
petitioners are willing to settle the matter.
আমি যা বলবো সত্য বলবো
সত্য বই মিথ্যে বলবো না
সত্য বই মিথ্যে বলবো না
কোনো কথা গোপন করবো না
কোনো কথা গোপন করব না
আপনার নাম
অনুব্রত কোলে
বানান বলুন ইংরেজিতে
ANU
ANU
BRATA
BRATA
KOLEY
বাবার নাম
ভৈরব কোলে
রব কোলে
BHI RAB KOLEY
আপনার বয়স
25 বছর
25 ইয়ার্স কি করেন আপনি
একটা দোকানের কর্মচারী
বাড়ির ঠিকানা বলুন সম্পূর্ণ ঠিকানা বলবেন
চাকপোতা দক্ষিণ পাড়া
সম্পূর্ণ ঠিকানা বলুন
চাকপোতা দক্ষিণ পাড়া
তিনপাড়া
আমতা হাওড়া
আমতা হাওড়া পিনকোড বলুন
711401
711401 বলুন আপনি কি কথা দিচ্ছেন যে যখনই দরকার পড়বে আপনি কোর্টের সামনে হাজির হবেন
হ্যাঁ কথা দিচ্ছি
Yes. আপনি কি জানেন এই যে কথা দিয়ে কথা না রাখার পরিণাম কি হতে পারে
না
আপনার জেল পর্যন্ত হতে পারে
ঠিক আছে
Yes. আপনি কি কোর্টের সামনে আপনার সম্পত্তির হলফনামা দাখিল করতে চান
হলফ-
আপনার যা কিছু আছে এফিডেভিট অফ অ্যাসেটস
হ্যাঁ যদি প্রয়োজন হয় সেটা করতে পারি
ইয়েস নেমে যান। এই মামলায় আর কেউ আছে? কে বলবেন?
বাংলায় বলবো।
একটু সামনে গিয়ে শুনুন। বলুন, আমি শপথপূর্বক বলছি
আমি শপথপূর্বক বলছি,
এই মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
সত্য বলবো,
আমি যা বলিব সত্য বলিব,
সত্য বই মিথ্যে বলবো না,
সত্য বই মিথ্যা বলিব না, কোনো কথা গোপন করিব না।
আপনার নাম?
ভৈরব কুমার কোলে,
ইংরেজিতে বানান বলুন।
BHAIRAB।
বাবার নাম?
লেট জয়ন্ত কোলে।
আপনার বয়স?
69।
করেন আপনি?
আমি চাষের সঙ্গে যুক্ত আছি, চাষবাস করি।
বাড়ির ঠিকানা বলুন, সম্পূর্ণ ঠিকানা।
গ্রাম চাকপুতা, দক্ষিণ পাড়া,
ভিলেজ চাকপুতা,
দক্ষিণ পাড়া, পোস্ট আমতা,
আমতা,
ডিস্ট্রিক্ট হাওড়া।
পিনকোড?
পিনকোডটা কি
আপনি বলবেন না?
আমার জানা নেই। হ্যাঁ,
বলুন, আপনি কি কথা দিচ্ছেন যে যখনই দরকার পড়বে কোর্টের সামনে হাজির হবেন?
হ্যাঁ, ওনারা যা বলেছেন তাই আমি, হ্যাঁ
আপনি কি জানেন কথা দিয়ে কথা না রাখলে কি হতে পারে?
হ্যাঁ
হ্যাঁ।
জানলাম।
আপনি কি কোর্টের সামনে আপনার সম্পত্তির হলফনামা দাখিল করতে চান? অ্যাফিডাভিট অফ এসেটস, আপনার যা কিছু সম্পত্তি আছে তা কি একটা হলফনামায় আপনি কোর্টের সামনে পেশ করতে চান? হ্যাঁ বা না?
হলমনামা আমি করতে পারবো না।
আপনার
না।
যা কিছু সম্পত্তি,
হ্যাঁ 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 হ্যাঁ।
কিসে বলবেন?
বাংলা।
বলুন, আমি শপথপূর্বক বলছি
আমি শপথপূর্বক বলছি,
এই মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
যা বলবো সত্য
যা
বলবো,
বলবো সত্য বলবো,
সত্য বই মিথ্যে বলবো না,
সত্য বই মিথ্যা বলবো না,
কোনো কথা গোপন
কোনো
করবো না।
কথা গোপন করব না।
আপনার নাম?
অনুপম পাল।
ইংরেজিতে বানানটা বলুন।
ANUPOMPAUL।
POM
POM PAUL।
বাবার নাম?
লেট অবনী মোহন পাল।
লেট অবনী মোহন পাল।
ABANIMOHNPAUL।
আপনার বয়স?
49।
49 years। কি করেন আপনি?
আমি কাজ করি।
কি কাজ করেন?
যেখানে যখন যে পরিস্থিতিতে যেমন কাজ পাই করি, কোনো পার্টিকুলার কিছুর ওপরেতে না।
আর বাড়ির ঠিকানা বলুন।
গ্রাম আনুলিয়া, উত্তরপাড়া। আনুলিয়া, উত্তরপাড়া। পুলিশ স্টেশন পেরো, জেলা হাওড়া, 7,11,401।
বলুন, আপনি কি কথা দিচ্ছেন যে যখনই দরকার পড়বে কোর্টের সামনে হাজির হবেন?
হ্যাঁ, হব।
Yes. আপনি কি জানেন কথা দিয়ে কথা না রাখার পরিণাম কি হতে পারে?
হুম।
Yes. আপনি কি কোর্টের সামনে আপনার সম্পত্তির হলফনামা দাখিল করতে চান?
হ্যাঁ।
নেমে যান।
Check down. This court by order dated 27th November 2025 and this court by order dated 27th November 2025 had issued warrant of arrest against award letter number 1, 2, and 3. Full stop. Award letter number 1, 2, 3 have been produced in the court. Warrant of arrest is discharged. Oath has been administered. The award letter number 1, 2, and 3, all three undertake to file their affidavit of asset within a period of 2 weeks.
Well, 3 weeks after the
A period of 3 weeks. Full stop. Learned and also undertake to be remain present for examination or for any other purpose as required by the court. Learned counsel for the respondent has entered his appearance on behalf of award letter number 1, 2, and 3. He seeks and is granted liberty to file his wakalatnama. You'll file your wakalatnama.
No, my lord, till time not, my lord. Because, my lord, the copy has not been served upon us till time.
So you'll file your wakalatnama.
Definitely, my lord. I will file the wakalatnama by the next date, my lord.
Seeks and is granted liberty to file his wakalatnama. List this matter after.
My lord, if a direction may kindly be given upon them to serve me a copy, my lord.
Give a
Will
copy.
serve.
4 weeks.
Obligement.
Grateful, Lordship.
Yes, Mr. Banerjee.
Right, this, my lord, item number 15. My learned friend was to take an instruction is agreeable, my lord.
Still agreeable to
The
an appointment.
award can be set aside and we can go to a new arbitrator, my lord.
All right. So this is like that online one or what is it?
No, my lord.
Then?
This is, my lord,
What
a
was backdated?
senior member of this bar was appointed, my lord. Let us not go into that.
Yes,
my
my
lord. A member of the bar, my lord. So
Where's the file?
15. 1-5.
Learned counsel for the Mr. Das. Learned counsel for the petitioner. Both the parties state that the award can be set aside without getting into the merit of the matter. Full stop. They pray that this court they pray this court to appoint an arbitrator.
we
to
give consent, my lord. Both of us give consent.
Both the parties consent to an appointment of an arbitrator to adjudicate the dispute between the parties
Afresh, my lord.
afresh.
Afresh.
All the
So,
points of contentions remain open for the arbitrator to adjudicate. Full stop. Mr. Give a name.
Lordship appoints anybody. I think the claim is around 68 lakhs, my lord. Around 68 lakhs.
Any good lawyer?
As your Lordship pleases. We'll leave
I
it.
know very few people. Mr. Banerjee, give a name, give a joint name.
Bishwarup Bhattacharya ki kore dao na. Bishwarup Bhattacharya ki kore dao.
Bishwarup?
Bishwarup Bhattacharya.
Mr. Bishwarup Bhattacharya. Give his particulars.
Yes,
Is appointed as an arbitrator to adjudicate the dispute between the parties. He shall be at liberty to fix his fees and other terms.
Under the fourth schedule, my lord.
And in accordance with law.
Yes.
Deeply obliged.
Grateful, my lord. So the 34 is disposed of.
With the above direction, the present petition is disposed.
Deeply obliged.
Amit. Grateful. বুঝলি Grateful. Grateful.